What's going on, everybody? TRAE4JUSTICE back in the building, coming at you guys with day 11 of the Darrell Brooks trial. Now, in this day, we have the return of Detective Casey, and I can really see what you all are talking about when it comes to the tension. It seems to be building as the days are going on, especially when it comes to how Darrell is behaving. Like, he seems to be becoming more unbearable as the days go on, so I definitely see what you all are talking about. But I want to say happy Father's Day to all the great fathers of the community, and happy Juneteenth to everybody as well. I hope you're all doing good and you're staying safe wherever you are. Okay, I promised myself I wouldn't make this intro too long because the last one was insane. So I just want to say thank you to a few people that donated. Thank you so much to Nora Griffin for a $15 donation. I really do appreciate it, and thank you so much for continuing to watch along and for sticking with me. Thank you so much to Catherine Perinara for a $15 donation. I'm sorry if I didn't say your name right, but I really do appreciate it, and thank you so much for watching along and for sticking with me. I'm laughing before I even say this one. Thank you so much to Sore Throat for a $5 donation. I really do appreciate it, and thank you for watching along and for sticking with me. And last but not least, thank you so much to Brenda Embley for a $5 buy me a coffee donation. I really do appreciate it, and thank you so much for watching along, for sticking with me. But most importantly, I want to say nobody has to send me a single thing. What I will say is, if you would like to donate to the community of Waukesha, there are links pinned at the top of the comment section. So if you're looking for resources to give to the actual community and the victims instead, there are resources down there for you to do that. Okay, hopefully I'm not forgetting anything I want to mention, but I don't want to hold you guys up. So thank you, and I hope you enjoy the video.
All right, good morning, everyone. The court will call State of Wisconsin versus Darrell Brooks, case number 21 CF 1848. May I have the appearances, please?
Here we go.
Leslie Basie and Zach Witchow appearing for the State of Wisconsin.
Good morning, sir. Please state your name for the record.
Just 1 second. Make sure
Okay, I am not waiting for your sovereign citizen speech.
that name for the record.
Reflect that the individual known to
go.
this court as Darrell Brooks is present in
We are
person.
not gonna wait for
in
that.
custody. He is wearing street clothes, specifically a suit and tie and a mask as well.
And don't consent to being called that name.
I understand, sir. All right, I do want to put on the record I gave the parties this morning. It's an excerpt from a judicial bench book on opening statements. It's about a page and a half. I thought it would be helpful to provide to Mr. Brooks as he puts together his opening statement. It has reference to some Supreme Court rules, SCR, some case law, talks about the manner and purpose, scope.
Basically, another document he's going to use to say that this isn't fair. That's all this is going to be.
And other things. And as I indicated yesterday, sir, I like to call it the roadmap. It's referred to here as a framework so that the jury can better understand and evaluate evidence. It must also be based on the law and the evidence you believe is properly admissible. I'm going to further advise you at the time when you do make your opening statement that it not reference subject matter jurisdiction. That is, despite what I know you believe to be to the contrary, it is not a requirement to be proven in this case. It is not a factual or legal argument that is accurate, and therefore I'm prohibiting you from referencing that during either opening statements or closing arguments.
Oh, no. He's definitely going to do it.
With that, I believe
For the
there's...
record, is this the which you're referring to? This
The page and a half is from my judicial bench book. I thought it would be helpful to you so that you have a better awareness and understanding of the manner and purpose of an opening statement. This is what guides me as I preside over cases.
okay? I accept for value in return for value these documents. I don't know why the reference to subject matter jurisdiction in the opening statement.
Who cares? Just
Pretty
take what she
aware
said and
that
move on with your life,
that
all right?
Wouldn't be part of an opening or closing statement. I don't
Okay, great.
get why that's
I wanted to make the
relevant.
record clear. So I appreciate you indicating
It's
to me
something
that
called an example.
you're aware of that.
Even though subject matter jurisdiction has not been proven on the record and should
Sir,
be
it does
addressed.
not need to be proven on the
It-
record. It's established by law and by the fact that, as my written decision indicates, commenced when the criminal complaint was filed in this case. It's conferred by Constitution and by statute.
And who was the complaint filed by? Because subject matter jurisdiction has yet
I'm
to
not
be
going to go
proven on
down
the
this
record.
path today. I'm just advising you, you cannot reference that in your opening
I mean,
statement.
That was something I've already had the common sense to know, but also subject matter jurisdiction has not been proven for the record.
All right, next topic then. I believe the state has
Should be
filed a
proven for the record
motion.
by the prosecution.
Objection is noted.
I'm so thankful
It
that
is
she's
not
just
legally
moving on
sound.
past him.
It's
Who
overruled.
cares what he
Definitely
wants to talk about at this moment? Who
All right,
cares about your
Attorney
subject
Opp,
matter
I'm going to turn
jurisdiction?
to Attorney Opper. I believe they filed a motion this morning. Has it been pulled through? I probably just need to refresh, but Madam Clerk.
It was served on
Jeez.
us last night in the jail, Your Honor.
I'm guessing he's
All
going to
right,
say he
go ahead,
didn't
you
get
can
it.
make. Let me
I
just-
didn't look at the document. I accept the accept for value, return for value the document. I didn't look at it.
It is so ridiculous he thinks it works that way. Hey, but to be honest, the fact that he thinks it works this way, he made it so easy for them to put him under the prison. As much as, like, you know, we get upset about that kind of stuff, that he's trying to force a trial, like I said, to go the way that he wants it to, which is like he tries to apply these sovereign citizen rules to an actual trial. Even though it's annoying, he made it so easy for them to put him under the prison. So for that, I'm actually happy.
So I don't
And look at the look in his eyes as
know
if
what
they're
I'm
supposed
say
to.
that.
This was
Well,
like a
let me offer
checkmate
two
moment, I
motions
guess,
from
in
you.
his mind.
Your Honor, we are moving to amend the information with respect to one word in the entire document. We're asking to change the location of count 76. The information reads, as it reads right now, it reads at Frame Park. We're asking to change that to near Frame Park. We believe that that's a more consistent statement that aligns with the testimony of victim PPP, Erica Patterson, as she testified in this trial.
Oh
We're
boy,
not asking
Erica's
to
involved
change
with this.
any criminal charges. We're not
Which
asking
means-
to change any dates. It's, I think, a very small change in the charging document. The defendant has been on notice of the facts of this transaction. It's reflected in a number of police reports and Ms. Patterson's recorded statement, which the defendant has copies of. And so I don't think that there's any grounds for a claim of prejudice by this change, and we're asking to move forward with that amendment to the information.
Okay, I feel like this is going to make him super aggressive now. He just said his name, or not her, he just said her name, and now it's probably going to throw him like over the edge. He's going to get extremely angry right now. I'm guessing.
All right, thank you. Any position on that, sir?
Yes. First of all, for the record,
Let's hear it. Let's get the clown
there
show
were
going.
originally 2 charges associated with this one party, and these charges have been charged for the better part of a year. I feel that if there was essentially one word that needed to be changed, it's been more than ample time for it to be changed. Even after one of the charges was dismissed, it could have been, that topic could have been visited at that time for it to change. I don't think changing one word at this point really has any bearing on the testimony or the actual charge. I don't understand why a motion needs to be heard about one word.
He's talking in circles now.
Is, I think, kind of at this point kind of a moot point. It's been charged like this for a year, basically. The language hasn't ever been referenced to being changed before yesterday. So what is the significance of this now at this point?
Repeat it one more time for us, Darrell.
Thank you, sir.
Okay, I guess he actually
Court is
finished the
guided
point.
by Section 971.29 sub 2 of the Wisconsin statutes, which provides at the trial the court may allow amendment of the complaint, indictment, or information to conform to the proof where such amendment is not prejudicial to the defendant. Case law states that when an amendment to the charging document does not change the crime charged, and when the alleged offense is the same and the results from the same transaction, there is no prejudice to the defendant. State versus Wickstrom, 118 Wisconsin 2nd 339, found at page 348. It's a Court of Appeals case from 1984. And also, I point the parties to State versus Durango, 229 Wisconsin 2nd 1, and State versus Gerard, 189 Wisconsin 2nd 505. The first of those two cases is a Court of Appeals case from 1999, and then the second of those referenced is from the Supreme Court from 1995. I'd also point the parties to State versus Frey, 178 Wisconsin 2nd 729, a Court of Appeals case from 1993. As far as whether this is a moot issue or not, I'll find that it is ripe for determination by this court to hear this motion, and that is because the jury ultimately will be instructed similarly to what the jurors were instructed at the beginning of the case. The charges are read. Those are based off of the information, and this proposed amendment does conform to the proof. There is no prejudice to Mr. Brooks. It does not change the charge in any way. It is still the same offense. It's still from the same general information that was indicated in the criminal complaint. So for all of those reasons, I will grant the state's request to amend the information, and the state may file that document as soon as possible.
I have a question.
And okay, that's something. This is like a point that's really not worth arguing about, you would think. I mean, it's just a word that they changed in the document. And she just explained right now that, yeah, you're right, it has no changes to the actual charges that were brought against you. But instead of him just saying, okay, well, this whole like thing, it's nothing to really argue about, I have a feeling he's going to actually try to argue about this for a good 30 minutes or so. I mean, it's something to take up time. So whatever he can latch onto to take up time, that's all that really matters in his mind. Like, this is really nothing that's worth arguing about, though. But
question about that. So this same person is scheduled to testify again. What if something changes in the testimony?
I'm not going to answer that, sir. It would require me to speculate on what that situation might be and to give an advisory opinion, which I will not do.
Well, what happens if that happens?
I'm not going to answer that, sir. I can't. You're asking me to give an advisory decision. I'm not going to do that. I'm not allowed to do that, actually. Okay, so we dealt with that then.
Makes no sense.
The state has not.
once again, we'll bring you a
yet.
box of Kleenex.
Will the state
It doesn't matter.
calling any other witnesses?
Yes, Your Honor, as indicated yesterday, we do intend to recall Detective Casey to the stand, and I'd like to make a record in that regard, please.
Go ahead.
Your Honor, Detective Casey did testify once for the state early in the presentation of the matter. His focus at that point was largely on assisting the jury in understanding the layout of the parade route, giving background and contextual information to the jury, the different parade units that were impacted, what they looked like. We showed several videos with Detective Casey just for background and context purposes.
Right.
He then went on to describe his personal interaction with the SUV as it came through the intersection of White Rock and Main. And essentially, that was the bulk of his testimony during his first testimony. We're seeking to recall him now. This is not unusual. It is commonly done in cases. We never excused him from his subpoena. We never asked for him to be excused from his subpoena. We always intended to recall him. We did this so that we can efficiently present the information to the jury. The types of questions we have for him now go more to the investigation itself and his role as the lead detective in this case.
Right.
There will not be duplication or repetitive questions. I'm not going back to the corner of White Rock and Maine with Detective Casey during this round of testimony. We want to ask him essentially about how some of the victims along the parade route were identified. We want to ask him about some of the topics that have been addressed throughout the course of the state's case, as far as identification of the vehicle and identification of the driver. And we need to still introduce the certified bail forms from Milwaukee County for the 2 bail jumping counts. So he will be asked about that. I estimate my direct examination of Detective Casey would be about 20 minutes. So this is not going to be repetitive. It's information, again, that he has as the lead detective in the case to assist the jury in understanding some of the things on the back end that he was involved in, not his role at the parade. So we are, we have been very efficient in our presentation. I believe Your Honor would agree with that. We're not wasting time here, but we just have a few more questions to wrap this up.
And that was beautifully said by DA Sue Opper, because this is a trick that Darrell commonly uses to try to once again say that it's not fair, like the entire process is not fair. Like, it's insane that I'm sure with them, like, it's insane to them that they have to put this kind of stuff on the record. But at the end of the day, it's important just to make sure this dude doesn't get out. So, like, I get it, but I'm sure to them they're like kind of in disbelief at the fact they even have to do that, to like say that, hey, this is something that's commonly done in a trial. You know, I know you don't know that because sovereign citizen baby boy tactics and all this stuff, but this is something that's supposed to be done in a trial. So they have to put it on the record, and also he's now informed of it, but he's going to pretend like he's not. And even now, she just finished saying what she's saying. He's going to argue about it. So none of it matters on that part of it. Like, informing him doesn't really matter because he's just going to argue either way. But it's important for them to put it on the record, so I get it.
All right. Any position from you, sir?
And yes, I do. And I'm going to start with what was just said.
Here we go.
The prosecution feels that they've been efficient in their presentation. So it seems like to me.
So why do you need to bring them back?
An attempt to get more questions in that could have been asked in the first place. If Your Honor recalls,
she literally just said
Detective Casey was testifying for quite some time, to the point that we actually had to have a break before I can cross-examine Detective Casey, if you recall. He was up there quite some time. That was more than enough time for any other foundations to be laid, any questions to be asked at that time. And also, from my recollection, he was asked to be excused. So essentially having him start off and then end it, I feel like it's an attempt to get questions that was maybe forgotten to be asked, answered. And essentially what more could be gained by a second testimony from Detective
She
Casey.
just said it.
What more can be
She
gained
literally
that
just said the
hasn't
line of
already been
questions.
learned? We learned about vehicles and identification by numerous witnesses. We've been through the inspection of the vehicle. We've been through DNA analysis of the vehicle. We've been through numerous things in regards to the vehicle. Even the reconstruction testimony. We've been through all of that. Seems like nothing more than to get extra questions answered that could have been asked from the get-go. As seeing as how he was up there for quite some time and none of those issues were raised at that time. What would be the significance at this point? When it's essentially I should be already presenting my defense at this point in trial.
Okay, so sorry to pause in the middle of that, but I have a question. So for everyone that like understands, or for everyone that's maybe an attorney or just understands the process of like being an attorney in a trial setting and all that kind of stuff, like, has there ever been a situation, or is it possible for like a witness to be just excused for that day? I don't even know how to say it. They're excused like initially, and then they're asked to come back, but then, you know, either the defense or the prosecution can say, well, there's really no reason to bring them back. And the judge actually grants that and says, well, actually, I don't think it's a reason either for them to come back. But has there been a situation, or is it possible for a judge to actually go back on that and say, well, now that I heard, like in this situation, what Darrell is saying, like, is it possible for her to actually hear him out and say, oh, yeah, no, there is no reason for him to come back? Not that she will in this situation. I don't know. Just curious about it, but if anybody knows,
the relevancy of it,
please let me know.
To my knowledge, he was excused from his subpoena. So,
Thank you,
what's the
sir.
relevancy?
Thank you, sir. The court has discretion under 90611. It's a statute I've quoted with frequency during the course of these proceedings. I've listened to the state's offer of proof. I've listened to the objections made by the defendant. In my discretion, I am going to allow Detective Casey to be recalled for the reasons laid out by the state. As I understand his proposed testimony today, it is not to rehash topics that he was questioned about initially. This has to do with his investigation and role subsequent to the initial contact with Mr. Brooks at the beginning of the parade route. And as the state indicated, we'll address certain things, including identification related to the vehicle, of the driver throughout the investigation, identification of certain victims. In addition, there are 2 additional charges for which the state has not yet presented testimony, so it's proper for those as well. It's relevant, and I will allow it for those reasons. So the state will be able to recall Detective Casey, and we'll have that done, obviously, when the jury is brought out. Any other preliminary
incoming
issues
tantrum?
Your Honor, just I am working on going through our list of exhibits, and I will work with your clerk to make sure that everything that I'm showing was admitted and accepted by the court is what she has, so that we can clear that up before we actually rest.
All right, thank you. Anything preliminary from you, sir?
Yeah, just a quick question about that last thing again. I will be able to re-cross-examine.
Oh, yes, you will.
And is essentially anything left off limits to my cross, or what?
I mean,
I may limit, depending on where we go, if the questions deal with what he testified to previously. It's primarily to cross-examine based on the new testimony. However, 90611 also says this: A witness may be cross-examined on any matter relevant to any issue in the case, including credibility. It does say in the interest of justice, the judge may limit cross-examination with respect to matters not testified to on direct. So I'll give you some leeway, and I'll trust the state will make appropriate objections, and I'll rule on them if and when they're made.
Because I'm not intending to go too much back into the previous testimony, but I think it made a few points from the earlier testimony may come into play, and I just wanted to make sure
I think that's fair.
that wouldn't be a problem.
I think that's fair, sir.
Also, really quick,
I don't know.
I did look over some information provided by the prosecution as far as the pretrial offer that I did not have knowledge of until, I don't know if that was today, Thursday. I don't know if that was Monday or Friday or Monday, one of those days. I've put together, started to, I won't say it's completed, that wouldn't be fair to say. I've put together, or started to put together a counter offer, so I just wanted to advise the court that I was putting that together.
All right, thank you, sir. If and when you do provide that to the state, please let me know so we can make a record of that.
Okay. Another question. I got a bunch of questions on this day. Okay, so the pretrial offer. Somebody said in the comments, and I didn't look too far into it, he received some kind of plea deal from the prosecution. Is that what he's referring to when he's saying like the pretrial offer? I'm gonna look it up here. Like, I have a bunch of stuff that they were talking about. I'm just Googling everything, but yeah, is that basically what they're referring to? Like, he was offered a plea deal and now he's trying to pretend that he didn't know about it because, you know, he fired his previous attorneys, or he fired his real attorneys that were representing him. And I guess they knew of it, but they were fired. So what can they do about it? Like, hey, they can't come back and tell them. I don't know. But if that's what they're talking about, please let me know. I'm going to probably Google it here in a second, but yeah.
All right, anything else? If not, then we'll have the jury brought out.
We do have one last large map here, Your Honor, I'm going to ask to put up and face backwards like we did the other day.
All right, go ahead since the jury's not here.
Disgusting. I'm going to mute this so you all don't have to hear it. He's like blowing his nose right next to the microphone. Okay, so I looked it up and it says an early opportunity for a defense attorney or prosecutor to resolve a criminal case before going towards trial. So I think that is what they're talking about. It's just something that where they can come together and actually work it out. So, or not work it out, but maybe that's what they're referring to about the plea deal is what he's talking about. That's until I see the comments, that's just that's what I think he's talking about, but I'm sure you all are going to let me know. And thank you for that. Staring down the jury once again. Attempting to intimidate.
Thank you, everyone.
As an
Please be
inmate.
seated, and good morning, ladies and gentlemen of the jury. I know it's a little chilly in here. I'm not sure if that will change now that we're all in here. If at any time that temperature is too cold for you, let me know and we can have that adjusted. All right, Attorney Opera, you may call your next witness.
Thank you, Your Honor. The state would recall Detective Tom Casey.
Good morning, Detective
Here we
Casey.
go.
Please make your way to the witness stand. When you get there, please remain standing. Raise your right hand, and Teresa will swear you in.
It has been so long since we've seen Detective Casey.
Shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you, sir. Please have a seat.
Okay, people in the
Please
comments
state
said
your first and last names for the
this would be
record.
good, so.
Thomas Casey.
Thank you. Go ahead, Attorney Opera.
Thank you. Detective Casey, I'd like to begin by asking you to refer to the item behind you. There's a large poster board there. If you could please place that on the easel and identify the exhibit number for the court.
It's exhibit number 15.
Thank you. And we've
Pretty
had
sure I already got
testimony
this.
about this exhibit throughout the trial. Is that right, sir?
Yes, we have.
All right. Your role in this case was what, sir?
Objection, leading.
Overruled.
Initially, I was on traffic control for the parade. Shortly after the incident happened, I was assigned as lead detective for the case.
Were you the individual who created this map, States Exhibit number 15?
Yes, I did.
Okay. And I would like you to talk a little bit about how victims were identified in this case.
Objection, leading.
Overruled. Foundational. The witness may answer.
So at least initially, can you tell us, like, in the day or two after the parade, what happened?
Objection, leading.
Overruled. You may answer.
So initially, that night, we knew that the victims were taken to different hospitals around the area, generally 5 different hospitals. So at the beginning, we began by having detectives assigned to each hospital. Waukesha Memorial Hospital received the most patients, so they also had a lieutenant that was assigned there as a team leader. As the patients came in, they were identified by detectives. The hospitals also provided us with lists of patients that they had, and we went through those lists and tried to identify people that came in and were being treated.
And then eventually, were there follow-up interviews conducted with these individuals?
Yes, there were.
What if the individual was a person under the age of 18?
Objection, leading.
Overruled. You may answer.
If the person was a minor under 18, then we would reach out to their parents, talk to the parents. Some of the kids weren't able to talk to us, but we got the majority of their statement from their parents.
Okay. And do you believe that the names on Exhibit 15 truly reflect all the injured victims that you were able to identify in the course of this investigation, sir?
Objection, statement.
No, I do not.
Hold on. There's been an objection. It's overruled, and the witness will repeat his answer.
No, I do not.
Can you explain that?
Objection, leading.
Overruled.
Just because of the scope of the investigation, we had so many people that were hurt, we had to come up with some kind of parameters to limit the people that we would call victims. One of those parameters is that they had to receive treatment at a hospital. Another one is that they had to be in the street when their injuries occurred. So there are some people that were injured, maybe on the sidewalk, trampled by the crowd, or received injuries that they didn't get hospital care from. You know, and unfortunately, I learned later on there was even a person that was in the band that somehow we missed her being reported that she received a broken leg. So there are some that are not on the map, but all the people that have been charged are on the map.
And really quick, I want to say thank you to everybody that let me know about Wilhelm Hospital. I think I'm saying his name right, but that was one of the members that actually passed away, which is horrible. He's one of the husbands of the dancing grannies. And I remember when we talked about that one, like when one of the dancing grannies talked about it, and that was one of the ones that nearly brought me to tears. Like, I don't know if you all remember it. I don't remember what day exactly, but that was one of the heaviest testimonies that I've heard here. Like, when they talk about the dancing grannies and the children that were, oh man, it's just a lot. But thank you so much for letting me know in the comments. But I just wanted to say that.
So you mentioned people on the sidewalk. We did have some spectators testify in the trial, correct?
Objection, leading.
Overruled. Foundational.
Correct, but they were more in the roadway or on the curb, not on the sidewalk, or not running away from the incident when it happened.
I see. So was, in your mind, when you were leading this investigation, trying to identify victims, what was the importance of the SUV in the injuries that were caused?
Objection, leading.
Sustained as to the form of the question. Please rephrase.
Why were the spectators that are on this map included?
Because they were directly contacted by the SUV that came down the street.
If a person were injured because they were trampled by the crowd, are they on this map?
We
Objection
exclude those.
speculative.
Overruled. The detective may answer.
Those people were excluded from the map.
There were some people like that, right?
Yes, there
Objection
were.
leading.
Okay.
Please make
Sorry.
sure. Thank you. I'll allow his answer to stand. Next question.
All right. I'd like to
I love when they do
put
that.
up for you exhibit number 32, which has been previously identified. I'm sorry, admitted.
32.
I'm sorry, you said 32? Yes. You said 32? Okay, thank you. Sorry, I just missed it.
This is another one
Just
I
to the
don't
witness or
have for
publish,
some
'cause
reason.
It's been received.
Yes, we are going to publish this, Your Honor.
Go ahead.
But I-
Permission granted.
Okay, thank you. And while we're waiting for it to come up in the jury box,
I don't have it on my screen.
It may take a second. Hold on. If it's not, let's check the cables.
What a child. He objects because it's not on his
I can see
screen.
it. The witness can see it.
32.
Thank you for letting us know, sir.
it's just the front tables, the back tables on, Your Honor.
Hold on. I'm going to stop source for a second.
Look at him waiting patiently to complain again. He lives for these moments.
I know. Anything? Yeah. You can see it on the screen, though, right, sir? On the there's screen, obviously, on the far side of the courtroom, and then to your right.
It's always better on here because
I understand. We'll get our tech guy over here to look at it, but it's previously been received, and we can see it on the two other monitors. So for now, we're going to continue. If there's anything new, I'll make sure to pause. Go ahead.
I'm surprised he's not throwing a
Detective Casey, I want
huge
to
tantrum.
focus your attention specifically as to the
Sorry,
extreme.
I talked over it a little bit, but I'm surprised he didn't throw like a major tantrum about that. Like, wait, what are you trying to pull? Why can't I see it? Like,
If there's anything new,
It's usually
I'll
what he
make sure to
does.
pause. Go ahead.
Detective Casey, I want to focus your attention specifically as to the extreme dance team. We heard testimony about several of the girls on the team being struck and injured. Do you remember that testimony, sir?
Yes, I do.
leading.
Overruled. It's foundational. The answer may stand.
Do you know if there were other people associated with the extreme dance team that were injured?
Objection speculative.
Overruled. He may answer.
Yes, I do.
And do you know the names of these people?
Objection. You're saying.
Overruled. He may answer.
Yes, I do.
What were their names, please?
Kathleen
Objection.
Pellmeyer.
Speculation.
Overruled.
that is just
He may
insane.
answer.
Go ahead, sir.
Kathleen Pellmeyer, Jennifer Stover, and Mitchell Lampine.
What was their role with the dance team?
Jennifer and Kathleen were support people.
That is hilarious.
Jennifer's daughter was marching the parade, and then Mitchell was there to hand out candy with his stepmom.
Okay. I'm going to now play, it's still not being displayed on our tables, Your Honor, but it is displayed on the two large monitors in the courtroom.
He stared at him for about 15 seconds.
So do I have permission to proceed?
Which exhibit?
This is 32.
Oh, yes. If we get to a new one that hasn't previously been received, then
Yes.
I will
Okay.
pause to get
All
the
right.
tech people in.
All right. And
Go ahead.
Objection
Bailiff.
to relevancy.
Overruled.
The bailiff confirmed it's on in the jury box, Your Honor.
Thank you.
All right, please play. From the 32-second mark, I'm sorry, 35-second mark to 47 seconds.
How long is the exhibit?
Why is he pretending like he actually cares
Looks
how
like it's a
long
minute
it is?
23, according to what I can see on my monitor.
definitely.
It is 123 total. We're only playing this 12-second clip from 35 to 47.
Thank you.
Hopefully they describe it again.
And please pause. Do you see any of the individuals you were just testifying about enter the screen, sir?
Objection, speculative.
Overruled. He may answer.
Yes, I do.
Could you identify them by using the touch screen?
Objection, leading.
Overruled. He may answer.
I'm going to draw one big circle.
Okay.
It has two individuals. It has Jennifer and Kathleen. Kathleen has the red jacket on, and directly to her left would be Jennifer in a black jacket.
Okay. A little hard to see right now, but as
Yeah,
they
it's very hard to see.
as they
Keep going.
walk, could you see two people walking there, sir?
Yes, ma'am.
Okay. Please clear the screen and continue playing. And pause. And I'm sorry because I can't see the counter, Your Honor.
It is at 44 seconds.
44 seconds. Thank you. Paused at 44. Do you see anybody else that you just testified to in the video at this point, sir?
Objection, speculation.
Overruled. He may answer.
Yes, I do.
And who is that?
Leading.
Mitchell.
Objection.
Overruled.
Mitchell Lampine.
Please circle Mitchell. Did you know Mitchell's approximate age?
Objection, speculative.
Overruled.
I believe he's about 10.
Okay. All right, we can take down 32. Did this video goes on to show the red SUV drive through the extreme dance team, correct?
Objection, leading.
It's foundational. Your Honor.
Overruled. It's foundational. It's previously been received. Go ahead.
Yes, it does.
To your knowledge of this video, sir, did those individuals, Mitchell and Ms. Stover and Ms. Pellmeyer, remain along the left side of the road there as the SUV went through?
Objection, leading.
Overruled. The witness may answer.
They were hit by the vehicle and then moved to the left.
Let's take a pause for a second. We
Yes.
are IT experts. Hopefully I can get this figured out.
It's a lot of pressure.
Go ahead.
Could you put something on the screen that's okay with you for the moment?
Next one will be 132 if you want to. No, I'm sorry, 55.
Look at him sitting here
It's on
waiting
now.
patiently for a moment to complain. That's
Hold on. Let's make sure. Do you have it now, sir? Yes.
Yes.
Oh, good. Great. It's on mine. It's on the witness. All right.
Just
Thank
like
you.
real life. You call the help desk and they show up and now it works. Yeah.
Jury monitors, we're working. It's not, hold on, let's make sure. It was just working. There's a delay.
Let me get that in my notes though. Exhibit 32.
It can take 30 seconds.
What exhibit is this one?
This is 55.
All right, it's on. Very good. We're up and working. And 55's previously been received, so go ahead.
All right.
Objection to the relevancy of 55.
Noted. Overruled. Go ahead, Attorney Alper.
Detective Casey, Exhibit 55. Can you see at the end of the road there, or the top of the screen, what unit is involved in Exhibit 55, please?
Yes.
I remember
tell
this.
Objection, leading.
Overruled.
It is the dancing grannies that are approaching from the right.
Okay. And one of the dancers, we have her testimony that was involved with the grannies was a woman by the name of Lola Hospital. Is that correct?
Objection, leading.
Overruled. It's foundational. The witness may answer.
Yes, she was.
Is there video showing Miss Hospital being struck by the SUV?
Objection, leading.
Sustained is to the form of the question. Please rephrase.
Sure. Is the exhibit, you've seen Exhibit 55 before?
Yes, I have.
Are you able to identify Ms. Hospital, yes, Lola Hospital in Exhibit 55, sir?
Objection leading.
Overruled.
Yes, I am.
All right. We're going to play the clip, Your Honor, from from 4 seconds to 8 seconds at 50% speed, and it is zoomed in on the middle of the road where the dancing grannies are located.
All right, go ahead. Thank you.
But it's like a heaviness I feel every time they show the parade footage. It's like it feels, I don't know, it's just sad.
Please describe for the jury what you just saw in the video, sir.
Objection leading.
Overruled.
I saw the red SUV driving westbound on Main Street, approaching the dancing grannies and hitting Lola Hospital and then striking 2 other dancing grannies.
When you say hitting Lola Hospital, what did you see?
Objection leading.
Overruled. You may answer.
I saw the left side of the car come in contact with her, and then her body moved to her left after.
Did Ms. Hospital report any injuries to the Waukesha Police Department?
Objection leading.
Overruled. The witness may answer.
Yes, she did.
All right, sir. I'd like to now ask that Exhibit 118 be published for the jury. This has previously been admitted.
Permission granted.
Objection to the relevancy of 118.
It's previously been received. Go ahead.
Sir, do you recognize the item shown in Exhibit 118?
Yes, I do.
And in addition to the photograph, have you had an opportunity to examine that item or items
Objection leading.
personally?
Overruled. The witness may answer.
Yes, I have.
And Mr. Johnson from the crime lab testified about these items yesterday, but I'd like you to tell the jury what you remember of these items, please.
Objection leading. Informative. The first part of the question.
Overruled. The witness may answer.
So this is the red SUV that was used in the parade attack. This is a picture of it taken after. I remember a hood from a white jacket and a hat, a black hat with snowflakes on it, being pressed in between the hood and the windshield wiper of the vehicle.
Objection to it being called an attack. I think that's a disparaging remark for the record.
That is just disgusting. I cannot believe he just said that. Well, what would you call it then? You drove through a parade. What would you call what you did right now? Okay. So now that I understand what this is, in the previous video, when they showed this, I was a bit confused. I thought like it was something that Darrell left behind when he left the SUV in somebody's driveway. I thought that this was something that he took off and like jammed into the hood, but after everyone explained it to me, that is actually the hood that William Hospital had when he was hit, and Lola is his wife. So that's why, like, right now this is it's a lot, you know. Like, every time they get to these types of parts, it's just the sadness I'm feeling is just insane, because what he did to this community, dude, is insane. It is just wild when you try to wrap your head around it. And a lot of you said in the comment section as well, and I'm confused, or not confused, that's the wrong word. It's like I can't believe how strong the community is to sit here right now. Like, there are family members sitting in the courtroom and they're listening to him say this stuff and they're able to remain calm and, you know, just allow this process to take place without jumping over the, I don't know what that's called. It's like some kind of barrier or gate or something, and trying to get their hands around his neck, because honestly, I don't know how they're able to be so strong about this. That's why I honestly admire the Waukesha community, because it's, yeah.
Your objection is noted, and the answer will stand. I will instruct the witness to simply describe what he is seeing without further characterizing it, as it will be up to the jury to determine the facts in this case. Go ahead.
Thank you. When you saw these items on the hood of the red SUV, did you later come to recognize where they may have come from?
Objection, lady.
Overruled. The witness may answer.
Yes, I did.
What did you
Oh, he's
determine?
upset now, I guess.
I determined that they were the jacket, hood, and hat that Virginia Sorensen was wearing while she was walking in the parade.
Like to display to the witness only, please, Exhibit 177. This has not yet been received, Your Honor.
Pure clown. I guess
Right,
he's
go ahead,
upset.
please.
You know what I think he's upset about? I'm sorry, I'm pausing all like way too often right now. But I think he's upset after he called it an attack. I don't know if you saw it. Detective Casey had a smile on his face, and I guess that Darrell is now he's angry about it. I hope he continues to wear that smile on his face and to continue to stare right in his eyes every time, like he's in between the questions. He looks at Darrell and just stares directly at him. You're an inmate, okay? Nobody's afraid of you right now. You can't do anything. So there you go. Be sad. Grab some Kleenex.
Is 177 on
Get
your
over
screen?
yourself.
Yes, it is.
And what do you see in Exhibit 177?
Objection, lady.
Overruled.
I see two dancing grannies carrying a Milwaukee Dancing Granny sign, and the woman on the left is Virginia Sorensen, and she's wearing a black hat with snowflakes, wearing a white jacket with a hood on it.
Move to admit 177 and permission to publish, Your Honor.
Objection to relevancy.
The objection is overruled. Exhibit 177 is received. Permission to publish is granted.
Said 177?
177, yes. And if the jurors will let me know when it's in the jury box as well, please. All right, thank you. It's there.
And again, just so we're clear on the record, please circle Virginia Sorensen in the hat in this picture.
Objection, lady.
Overruled.
That is Virginia, and then this would be the hat and hood that I believe was found on the SUV.
Detective Casey,
Oh, I see. Okay, sorry. So that's Virginia Sorensen's hat. But I thought okay, no. I'm not going to keep it paused, but
there were many videos that have been shown.
oh,
to
this
the
is
jury,
crazy.
correct?
Objection, lady.
It's foundational, Your Honor.
Overruled. The witness may answer.
Yes, there has been.
To your knowledge, are there any videos that display the license plate of the red SUV as it goes along the parade route?
Objection, lady.
Overruled.
Yes, there are.
Is it possible to capture a screenshot from those videos to see the license plate of the red SUV along the parade route?
Yes, there are.
I'd like to display for the witness only, Exhibit 150.
Go ahead.
Is 150 on your screen, Detective?
Not yet.
Okay,
It is now.
all right. Do you see Exhibit 150?
Yes, I do.
please describe what you see in Exhibit 150.
Objection, leading.
Overruled.
I see the red SUV that was driven through the parade route, and it's at the time when it was contacting the Waukesha South band members. In that photo, you can read the license plate number.
Do you believe this photo is a true and accurate representation of the events of the day?
Yes, I do.
Move to admit 150 and permission to publish.
Objection. How does this go to investigation? Show exhibits
Overruled.
on investigation.
Exhibit 150 is received. Permission to publish.
Was that an actual question or what? I don't know what that was he just said, but okay. A bunch of random words put together.
The image is a little blurry, correct?
A tad.
Can you please point out the
Oh, man, there it
license
is.
plates in the photo and read it for the jury?
Is it okay if I circle it?
Yes.
Overruled. You may do so.
ADP.
That is the license plate number,
9256.
and I read ADP 9256.
All right. Now I'd like to show to the witness only number 151, please.
Go ahead.
Please describe 151. Oh, please clear the screen, Madam Clerk.
$151.
This photo is of the red SUV on the parade route. It's just photo taken just prior to the Barris Logistics float, and the band director is in the lower left-hand side of the video. It shows the red SUV with the license plate number displayed.
Do you believe this photo represents a true and accurate depiction of the events of the day?
Yes, I do.
Move to admit 151 and permission to publish, Your Honor.
Objection to relevancy.
Exhibit 151 is received. Permission to publish granted. The objection.
That's very relevant.
I recall this state saying they had 140 exhibits. How did we get this many?
Keep going, Attorney Upper.
The dumbest
Detective, please
thing
describe what you
I've
see
ever
in,
heard.
151. I think you did describe it.
It's
Strike
insane.
that. Please circle the license plate and read it for the jury.
Objection, leading.
I told you he uses like baby brother antagonistic like ways to get things done.
Overruled.
ADP 9256.
Thank you. It's still not up. Okay, I'm sorry. Gotta wait for the jury.
Go ahead.
That's so weird. I
Detective
stares
Casey,
at the screen.
during your investigation, did you uncover any other videos linking Mr. Brooks to this same vehicle with this same license plate?
Objection, I don't consent to being called their name and it's leading the witness.
Overruled as to both counts. You may answer.
Yes, we have.
Could you describe this video for us, please?
Objection, leading.
Overruled.
There's a video that we obtained from social media that shows Mr. Brooks standing next to the SUV, and you can clearly see the license plate number on the vehicle. I believe the video was taken sometime prior to November 21st, 2021.
Okay, I'd like to display for the witness only Exhibit 175, please.
Go ahead.
That's ridiculous. That is insane.
Please identify 175.
This is
Objection. Relevancy.
Overruled. You may answer.
This is a photo. There's two individuals in the photo. The individual on the left, I know to be the person referred to as Darrell Brooks. It displays a vehicle, a red Ford, and it has the license plate number, which is displayed in the photo.
What is the source of this photo?
Objection leading.
Overruled. The witness may answer.
We obtained it through social media.
Okay.
Wait, I
think
gotta see this one.
This is a photo versus a video.
This is the photo taken from
Hold
a
on.
video.
I understand the objection. It's sustained. It's foundational. This particular question, the witness may answer. Go ahead.
This is
Overruled
a,
or sustain?
Overruled.
You said sustain.
What did I say?
Yes, you did.
Sorry. I meant it's overruled. The witness may answer. Sorry. I'm taking notes. I was writing the word source, and I think that's why I did that. In any event, go ahead and answer. Sorry about that for any confusion I may have caused.
this is a screenshot taken from a video.
Move to admit 175 and permission to publish, Your Honor.
Objection to that. What's the relevancy? I don't see the alleged defendant in here.
Your objection is noted. It is overruled, and Exhibit 175 is received. Permission to publish is granted.
I want to see this. Is this like an image of him standing next to the? Well, he says he's not in the picture.
Where's, oh, sorry.
The jury would also let me know when it's
What
in
is
the jury
this?
box monitors or on the jury box monitors.
Oh, you know what I think this is? I think this is the. Okay, people were telling me that he does. That he's a he's a rapper. Which I haven't heard his music yet, and I haven't seen any of the music videos. I think I saw like a thumbnail with something like this with him standing on the front, but that's not him. So I'm guessing this is him with his back turned. Hold on, I think we're gonna hear the music right now. Oh no! Oh no! This might be the first time I mute an exhibit
All right,
or
go ahead.
something. This might be it.
Detective Casey, is person you know as Darrell Brooks in this photograph?
Objection. I'll consent to being called their name and leading the witness.
Overruled. The witness may answer.
Yes, he is.
Please circle or X or mark in some fashion.
Yep, that's him.
How do you know that's Darrell Brooks there? His back is to us.
Objection leading.
Overruled.
I've watched the video in its entirety and I've seen his face in the video.
Darrell is gonna argue like crazy about that.
Okay, that can go down, please.
We don't see it right now, so how can you say that's me?
Detective Casey, in total, how many videos do you think were collected by the Waukesha Police Department during this investigation?
Objection speculative.
Overruled. You may answer.
We have at least 65 to 75 files. Some of those files contain multiple videos, photos, could be 10 each, so I would say probably 300 to 400 videos we've collected.
Wow.
What were the source of those videos?
Some of the videos came from different people that were at the parade. Some of them are from city-owned cameras, and some of them are from fixed surveillance systems from businesses that were in downtown Waukesha.
Were all of the videos that were available shown to this jury?
No, they were not.
Objection leading.
Overruled. You may answer.
No, they were not.
Have you personally observed and reviewed each of the video files available in this case, sir?
Objection speculative.
Overruled. You may answer.
Yes, I have.
To your knowledge, sir, did any video ever show a different person behind the driver's wheel of that red SUV?
Objection leading.
Overruled. The witness may answer.
I have never seen anyone driving the vehicle besides the defendant in any of the videos that I have looked at.
In any of the videos, were you ever able to see multiple people inside the vehicle?
Objection speculative.
Overruled. The witness may answer.
None of the videos that we have looked at showed anyone else in the vehicle.
Do any of the videos at any point show the red SUV coming to a stop a complete stop along the parade route.
Objection leading and speculative.
Overruled. The witness may answer.
I've never seen a video that shows the vehicle slowing or stopping while it was on the parade route.
Do any of the videos show the driver of the vehicle exit the vehicle to check on a person who had just been struck by the vehicle?
Objection leading.
Overruled. The witness may answer.
I never observed in the videos the driver of the vehicle to stop and check or exit the vehicle on anyone.
Please get the camera off him.
There was testimony earlier in this case about
Absolute
witnesses
cartoon character.
observing multiple people running from the car. Do you remember that?
Objection leading.
Overruled. The witness may answer.
Yes, I remember that.
Were there multiple reports like that, sir?
Initially, there were some reports like that.
When the vehicle was found on Maple Street, you weren't there.
Correct.
Objection leading.
Overruled. His
He's just
answer may stand.
spamming leading objections like.
Do you know what police activity occurred when the vehicle was found on Maple?
Objection speculative. He just stated he wasn't there.
Overruled. The witness may answer. He was asked, what does he know?
Yes, I do.
Please tell the jury what happened when the SUV was found on Maple.
Objection leading.
Overruled. The witness may answer.
Initially, Officer Moss went, he secured the vehicle, did not find anybody in the vehicle. There was an initial report that saw some other people running from the area of the vehicle. After that information was given back to us, we sent detectives down to the area to investigate further to see if we could corroborate and find out if that was true or not.
After that investigation, did you have other suspects or just one person?
Objection leading.
Overruled. The witness may answer.
Based on the information of what everybody saw on the parade route, and then the detectives that went back down to Maple Avenue where it interviewed the people that reported the people running, our investigation determined that there was only one person in the vehicle and there was no other suspects that we were looking for.
At some point in your investigation, Detective Casey, were you given a Ford key?
Objection leading.
Overruled. The witness may answer.
Yes, I was.
What was your understanding as to the source of that key?
I love
My
when he does
understanding
that.
that key was taken from Mr. Brooks when he was taken into custody and turned over to Detective Stern and Detective Carpenter.
Objection. I don't consent to being called that name for the record.
I love when he glances over at him like that and stares at him for like 15 seconds straight, because it like puts a spotlight on Darrell, not the usual spotlight that he loves to have on him. He's making it to where everybody has to look at Darrell in like an awkward way, and it shows just how silly he's being, like how stupid that he's behaving in this courtroom right now. So when he does that, it's hilarious.
Noted. Overruled.
How did you get it?
Objection leading.
Overruled. The witness may answer.
You just stated how you got it.
Overruled. He may answer.
Detective Stern brought me the key the morning after the incident.
Did you do anything with the key?
Yes, I did.
Tell the jury what you did, please.
Objection leading.
Overruled.
At that point, the vehicle was at the Waukesha County Sheriff's Department secure storage facility. Mr. Johnson was over there processing the vehicle. I went there and I took the key with me and I checked the vehicle to see if the key would work in the car.
What did you find?
Objection leading.
Overruled.
I found that the key worked the door locks to unlock the car. I also put the key in the ignition and it turned the ignition lock.
Thank you.
There it is.
Detective Casey, you've heard testimony about the manner in which the defendant was identified by the name of Darrell Brooks. Do you recall that testimony, sir?
Objection, I don't consent to being called that name. He's leading the witness.
Overruled. Foundational.
He is spamming
The witness
leading
may answer.
objections.
Yes, I do.
Did you endeavor to verify the identification of the subject you had arrested for this incident?
Objection, leading.
Overruled.
Yes, I have.
Did you verify his identity by the name of Darrell Brooks?
Objection, I don't consent to being called that name. Leading.
Overruled. The witness may answer.
Yes, I have.
How did you do that?
Objection, leading.
Overruled.
There were a couple different ways. One way is when a person is taken into custody, we take their fingerprints. We check that against other records that are kept by the state. Those fingerprints matched Darrell Brooks. I've also spoken to 3 women that he has children with. They verify that is his name that he has always gone by. I have also spoken to
That's
his
2.
mother, which states that that's the name that he has gone by always.
That's 3. But his
I'd like
name's
to
not
put on
Darrell
the
Brooks
screen for
according to
the
him. So.
witness only exhibit 88.
Go ahead.
Do you see exhibit 88, sir?
Yes, I do.
Objection to this. What's the relevancy?
Overruled. Go
Can you-
ahead.
Grounds for the overrule.
Relevant.
In what way is it relevant?
Please don't explain.
2 of the counts alleged in this case. Go ahead.
Can you please identify exhibit 88, sir?
This is a bail bond through Milwaukee County Circuit Court for Darrell Edward Brooks, the date of birth of 2/21/82.
To your knowledge, was Mr. Brooks on bail through a Milwaukee County case on the date of November 21, 2021?
Objection, leading.
Overruled. The witness may answer.
Yes, he was.
And what is the date of this bail form, please? I believe it's near the bottom.
The date on the bottom
Objection,
is
leading.
Overruled. The witness may answer.
That's ridiculous. He waited until he actually started talking a little bit and then objected.
2/21 of 2021.
Was Mr. We'll strike that. By classification, can you tell us the level of charges that Mr. Brooks was pending on for this bail?
Objection. You've already made a ruling on it.
Overruled. The witness may answer.
All the charges that I see in here are felonies.
To your knowledge, was this bail in full force and effect on November 21 of 2021, sir?
Objection.
Overruled. You may answer.
Yes, it was.
And in the middle of the form, do you see the conditions of bail that were set upon Mr. Brooks?
Objection, leading.
Overruled.
Yes, I do.
And I'm looking under paragraph B, the 3rd bullet. Do you see that?
Yes, I do.
Could you please read that bail condition to the jury?
Objection, leading.
Overruled. The witness may answer.
The state defendant shall not commit any crime.
Thank you. Move to admit number 88, Your Honor.
Objection.
Exhibit 88 is received.
I'd like to display for
We've already
the...
speculated to. How's that coming into evidence?
Overruled. And permission to publish.
I'm sorry, I did not seek to publish this, Your Honor.
Oh, all right. Turn that
I
off.
request a legal finding of fact for that.
The objection is noted. It's overruled. Continue. Attorney Opper.
Thank you. I'd like to display for the witness only exhibit 89.
He's getting, and I can tell exactly what you all are talking about now. I mean, I'm sure this isn't the worst he's going to be. But I can tell he's getting increasingly more obnoxious as we're getting closer to like day 15. Like he's always objected aggressively to everything that to every question the prosecution asks, but he is literally spamming leading objections, and he's just making random comments now about how something's not fair, even though it's like it doesn't even make sense at this point. It's never made sense at any point, but I'm starting to see what you all are saying. Like you can feel the tension is like starting to rise with every day that's getting closer to day 15, which is the end.
Go ahead.
Sir, can you please identify 89?
Objection.
Overruled.
Relevancy.
Overruled.
This is
This has been stipulated to as well. How's it evidence?
This is ridiculous. Can we kick him out at this
The
point?
objection's
Because
noted.
now
It's
he's just...
Overruled. The witness may answer.
I request a legal finding of fact for that too, Your Honor.
Noted. Overruled. Go ahead.
He hasn't done this in a while.
This is a bail bond through Milwaukee County Circuit Court
Requesting
for
legal
Darrell
finding.
Edward Brooks with the date of birth of 2/21 of 1982.
Is this a different case than what was displayed in Exhibit 88?
Objection leading.
Overruled.
Yes, it is.
Are you able to make any observations about the level of charges related to this case, sir?
Objection leading.
Overruled.
It appears that there's 4 charges, 2 of which are felonies.
Okay. And on the bottom of the form, can you tell the date that this bail was issued?
Objection leading.
Overruled.
Say it's 11/11 of 2021.
Directing your attention again to that same location in the middle of the page under paragraph B, the 3rd bullet. Could you please read the conditions of release that were set by the court in that case?
Objection leading.
Overruled. The witness may answer.
Defendant shall not commit any crime.
To your knowledge, sir, was this bail in full
He
force and
immediately
effect
broke
on
down.
November 21 of 21?
Objection speculative and leading.
Overruled as to both. The witness may answer.
Yes, it was.
Finally, sir, I'd like to put up one last item for you, or 2 items. 1 second, please.
We know he immediately broke that rule.
I'd like to display for the witness only Exhibit 13.
Objection. What's the relevancy of this? How does it say any foundation to testimony?
So now
I'll
hold on.
give the state some leeway to establish that. Go ahead.
Thank you. Sir, do you recognize can you tell if Exhibit 13 is a video, sir?
Yes, it is.
Okay. Have you seen this video before, sir?
Objection leading.
Overruled.
Still relevancy. Where's the relevancy?
The state is asking the foundational questions. The objection's a bit premature. I'll take it under advisement. Go ahead, Attorney Opper.
Yes, I have.
What does this video depict?
Objection leading.
Overruled. The witness may answer.
Objection speculative.
Overruled. Go ahead.
This video depicts the backyard at 4014 North 19th Street in the city of Milwaukee. That's the address of Dawn Woods, the mother of Darrell Brooks.
Oh,
And
I
on the
see.
On the lower left-hand corner, you can see a Ford Escape.
In the lower
Objection.
right.
I move to strike that. How does he know?
Okay, so now I see. I was curious to see what this was because he got, I don't know if you all noticed it, he immediately got like really agitated as soon as he saw the exhibit that they put up, like before we were able to see it. So I was curious to see what it was that had him freaking out. I knew it was either something that's related to Erica or something about his mom, because you all told me in the comments to look out for that. Like, whenever there's something mentioned about Erica or his mom, he gets more animated, more aggressive. I guess in this case, since it's the backyard, which some people told me he actually lived in the backyard. I had no idea about that. And then, like, he with the TV. So I saw some comments about this last time too. It's so many things, you guys. It's so many like details about this, like this story and the trial that you guys told me about. So apparently he had a TV, the TV that I saw in the front seat. He ran an extension cord from his mom's house to the truck or the SUV, and he was watching TV in the car. It's just the weirdest thing, man. Like, his own mom won't let him in her house. That tells you a lot about this dude.
Wait,
The objection's noted, overruled. You can ask him on cross-examination. You can question him about that. Go ahead.
In the bottom right-hand corner
He's so
of
angry
the
about it.
exhibit, do you see a date and time stamp for this video, sir?
objection leading.
Overruled.
Yes, I do.
What does it say?
It says 11/21-2021, and then it says 13:26:18.
What do those numbers represent, sir?
Objection leading.
Overruled.
To me, it means that the video was taken on November 21st, 2021 at 1:26 p.m.
And do you believe this video is a true and accurate representation of the events of that afternoon at that location, sir?
Objection speculative.
Sustained, if you could lay a little more foundation.
Sure.
please.
How did you come into possession of this video, sir?
The defendant's mother provided it to us.
Wow.
And do you know approximately when it was obtained?
Objection speculative.
Overruled.
The evening of November 21st, 2021.
Do you know if the defendant's mother was cooperative with police in providing the video?
Objection relevancy.
Overruled. The witness may answer.
Yes, she was.
Do you know if the video was provided to police when asked?
Objection leading.
Overruled.
Yes, it was.
Do you have any reason to believe that the video was altered or modified in any way before it was provided to police?
I do not.
I'm really surprised he didn't object there.
Move to admit 13, Your Honor, and permission to publish.
Objection. Relevancy.
Noted. Overruled. Exhibit 13 is received. Permission to publish is granted.
For the record, this is a video. It's 49 seconds in duration. We're going to play it in full. There is no audio, and it will be played at normal speed.
Yes, if the jurors would let me know when the monitors are displaying the video.
Who's he looking at?
All right, go ahead.
Wow. So this must be where him and Erica stayed. I think some of you told me in the comments. That is insane. There he goes.
Detective Casey, were you able
Okay.
to see any
Not even
emblem
gonna
on
pause.
the front grille of that vehicle as it drove away?
I would have to look at it again.
Okay, I'm sorry. Let me ask you this. Did you see any damage to the front end of that vehicle as it drove away?
Objection leading.
Overruled.
I did not.
Okay. I'm going to put up State's Exhibit 14 now, please.
Go ahead. Just to the,
Yeah, just to the witness only, please.
thank you.
Do you recognize Exhibit 14, sir?
Yes, I do.
What is the source of Exhibit 14?
This is a still shot taken from the video.
The same video we just saw, number 13.
Yes.
Okay. Move to admit 14 and permission to publish, Your Honor.
Objection, relevancy.
The objection's overruled. Exhibit 14 is received. Permission to publish is granted.
Sir, do you see Darrell Brooks in this photograph?
Objection, I don't consent to being called that name again for the record.
No
Noted.
one cares,
Overruled.
man.
Yes, I do.
Can you identify or, excuse me, describe the clothing items that you see him wearing in this photograph? Oh, it's not in the jury box yet, I'm sorry.
You can state your objection, though.
Leading.
Overruled. The witness may answer.
Okay, really quick. I was just going to say, it's like with every exhibit that comes out, like every exhibit that they display, it's insane that he's actually trying to fight this right now. Like, it really just goes to show you how much for himself he really is. Like, he injured numerous people. He injured numerous people, killed people, and he's still trying to fight this. Even now, there's a video on screen. Well, this is a screenshot now, but we literally just watched a video of him get into the vehicle that he used to do all of this. And he's still sitting here right now with the attitude, and his nose is up in the air. And it's okay. Let's keep it going.
Mr. Brooks is wearing a red t-shirt, blue jeans, and he has blue colored flip-flops on with white socks.
And what's the date and time stamp for this photograph, please?
It's 11/21/2021 at 13:26:08 hours.
And that's what time, sir?
Objection, leading.
On the 12-hour clock.
Objection, leading.
Overruled.
That would be 1:26 p.m.
All right, thank you. I don't have any other questions, sir?
Oh, and the clown show is about to begin.
We cross.
Which, this is just going to be an attack from start to finish. He despises Detective Casey.
13 and 14.
Here we go.
You see anyone driving the vehicle?
No, I do not.
Do you know if anyone's in the vehicle at the time that you see it pull away?
I would assume, based on my training experience, that when the vehicle pulled away, that there was someone inside the vehicle, because in order to move a vehicle, you have to manipulate the controls, the shifter, the brake, the accelerator. So my assumption is that someone is inside the vehicle doing that.
That wasn't the question. Do you see anyone in
That's
the vehicle?
the answer.
I object, Your Honor, that was the question, and he's already asked and answered. The question is, anyone can be seen.
The objections, not sure what the objection was, but the answer may stand. You can ask your next question.
He's trying to get an argument started.
175. You pull that up for the witness.
Would the state please pull that up?
All right, let's see what exhibit he's pulling up.
Witness only or published?
Publish.
Okay, thank you. Go ahead. Jurors, let me know when it's in the jury box as well.
Image of him on a ring camera. Oh, 175.
All right,
Just-
go ahead. It's in the jury
You
file.
just testified that this was the alleged defendant. How do you know that? Can you see a face?
Which question are you asking? Those were two.
Can you see the face on the circled individual in that exhibit?
In this clip, I cannot see the face of the person that is circled.
So how do you know who it is?
I can tell who that is because I have watched this video in its entirety, and I can tell that it is you based on all of my contacts with you.
So why were there not any other exhibits that can give credibility to you positively identifying the individual in this video?
Objection, argumentative,
Grounds.
compound.
Sustained as to the form of the question.
Is it fair to say that this is the only exhibit photo from the video?
Go
Can
ahead.
you clarify the only one that is shown today, or the only one that has ever been taken?
The only one that's
ever
the only
exists?
one that's
Could you clarify,
being
please?
shown right here today. Is this the only one that is an exhibit being shown here today?
Yes, this is the only one that we've shown today.
And you can tell just from this exhibit exactly who that individual is.
I don't believe that was my testimony.
I'm asking the question.
And you
Just
received
looking
an
at
answer.
this, no, but I know from looking at the entire video that it's you.
We're talking about this exhibit that's being shown right now during your testimony right now at this moment. Strictly that.
Could you ask your question, please?
I'm going to object, asked and answered.
Sustained as to the form of the question as well.
Would it be fair to say that from this exhibit 175 that they're looking at right now that you cannot tell who the circle individual is? Would that be fair to say?
That would be fair to say.
Can you clear the circle?
Thank you, Madam Clerk.
And do you recall what date you viewed this video, as you call it?
I have viewed this video multiple times. I don't recall the specific dates that I've seen it.
Was it relatively early on in the investigation?
There have been multiple times that I've watched this video. Some of them early, some of them as late as yesterday.
Do you recall seeing this video the same night of the incident or in the days following?
I did not see it the night of, but it would be the days following that I have seen it.
And at that time, did you have knowledge of?
Oh no. How did you find out who I was if you didn't know then? How can you say that's who I
Who that
am?
vehicle belonged to?
Yes, I did.
And did you have knowledge of the usage of that video? The usage of that vehicle?
I'm not sure that I understand the question.
Did you have knowledge of who may have been using the vehicle?
Objection vague as to time.
Sustained as to the form of the question, if you could limit or perhaps direct him to a specific time frame regarding the use of the vehicle.
At the time of the incident?
Yes.
And what? And can you clear that? And what information was that?
The information that I had is at the night of the incident that you, Darrell Brooks, were the person that were operating the vehicle.
And who did you learn that from? And for the record, I don't consent to that name.
Noted,
For the record.
overruled. Go ahead and answer.
Can you repeat your question, please?
Yeah, this is going to be a frustrating one for Darrell.
I'm gonna go another route on this.
You done with the exhibit, sir?
No, I'm not.
So you're withdrawing your question?
Yeah, I'm going another route.
All right, thank you.
You just testified to seeing the entire video that this steel frame exhibit came from, correct?
I testified that this came from the entire video, correct?
You said that you viewed the video in its entirety, correct?
The entirety, what we recovered from your social media account. I'm not sure if there is a longer version someplace, but...
Did you see the video in its entirety? The video that this exhibit came from?
Yes.
And are these the only two individuals that you observed in that video?
They are the only two that I recall seeing in the video.
Did you ever inquire about the identity of this individual?
No, I have not.
Wow.
Can you clear that circle?
Thank you, Madam Clerk.
Wow. So now he's throwing whoever this person is in the bus too. That's insane. But the way he's barking orders at Madam Clerk, this is...
Would it be fair to say that
Annoying.
from looking strictly at the exhibit that we're viewing right now, that both individuals have the same hairstyle?
That is wild.
It would be fair to say.
Can we clear the X's and clear the exhibit?
Go ahead. Thank you.
We go back to Exhibit 13. Publish.
Go ahead.
13. Let me see.
The state would assist, please.
13.
Oh, it's the backyard. We just saw it a second ago.
Can you play it? Well, just play it. I'll tell you when to pause if that's okay.
Go ahead.
It's not up yet.
Oh, thank you. We're going to wait until it's in the jury box.
Oh,
Okay, go ahead. Thank you. Just as a reminder, it's 49 seconds long.
I don't think I'm gonna need the. Well, I don't know. Yeah, I might.
Fisher Price attorney, man. Can you make up your mind about what it... Okay. All right.
Pause. Right there, the individual that you observe. Right here. Do you see them wearing a hoodie?
The person in that photo is not wearing a hoodie.
Do you see a hoodie anywhere present in this video?
No, I don't see a video or a hoodie anywhere in the video.
Can you take the X down? From this angle, it'd be fair to say that you can see the very front end of a vehicle, correct?
That is correct.
Can you see any windows or see inside the vehicle at that time? Or at the time that we're looking at right now?
You cannot see inside the vehicle at this time.
So it would be fair to say that just by looking at what we're looking at now, you wouldn't know if anyone's already inside the vehicle.
This has been asked and answered, Your Honor.
I'll allow it. The witness may answer.
This is a whole different.
I'm allowing it. Go ahead.
That is correct. From this video, you cannot tell if anyone else is inside the vehicle.
So it would be fair to say that you're not sure.
It's fair to say that I am not sure.
Can we pull this down? Whoa, wait. I'm sorry. Can you pull that back up for 1 second?
Same exhibit.
Same
Go
exhibit,
ahead.
13.
All right. The state would put that back
Right.
on display,
It does-
and there you go.
Do
Do you want any more of a plate or just the still?
we waiting for the jury or do they?
It's up.
No, we don't need it played.
Do you need it to go to a certain point?
Yes,
All right. Do you know what point?
I'm about to it right now. Looking at this house right here, do you see an address posted anywhere on this house?
In the photo that you circled, no.
So it'd be fair to say that you don't know the address of this house.
That is incorrect.
You just said that you don't see an address posted anywhere in this house. So from the vehicle, I mean, strike that, not the vehicle. I'm still looking in the corner right here. From the video that we're viewing right now, do you see an address posted anywhere on this house?
I do not see an address posted in this photo.
So judging by this, well, actually it's a video, but judging by this video, how can you know the address of this house?
Because I've been at this house before to talk with your mother. I've seen the address on the front of the house.
Judging by this video.
Hold on, you have to let him finish, because that was not the question you asked. You asked him how he knew. He can answer.
I knew he wouldn't like this answer.
I have been at this address before. I have spoken to your mother. I have been in the backyard of the residence. I've seen the address on the front of the house. I know this to be your mother's house. I recognize from this photo to be your mother's address at 4014 North 19th Street.
You recognize the house or the address? Because we don't see an address in this video.
I recognize this house to be that address from being there.
And had you already been there, as you say, and talked to people, as you say, before you viewed this video?
What?
I believe that I saw the video first, and then I was at the address.
So at the time that you saw this video, you didn't know whose house that was?
What does that matter, though?
That would be an incorrect statement.
You just said that you saw the video first before going to the house. Did you, or did you not say that? Would that be fair to say?
I guess I'm a little confused in your question. We received the video. We know from getting it from my mother that she said that that is where she lives. So I knew that this was where she lives when I watched the video. That was clarified for you.
I follow you, but that clarification wasn't stated before. So that's fair from the clarification of how you just clarified it. Can you clear the
You're
circle,
done with
please?
this exhibit?
Yeah.
All right, we'll take it down. Thank you.
Like, I don't know about you all, but it's like I kind of took that as him almost just accepting it. Like, okay, yeah, you got it from my mom. I can't even fight this any longer. Which, like, why are you fighting this to begin with? Your actual mom told him and actually gave him this video that we're viewing right now. There is nothing to argue about here. This is another situation where he should just not do a cross-exam. Like, with the evidence they're showing right now, there's literally no room for him to argue anything. Like, as soon as they showed this video, that should have been like a sign to him to just go, yep, I should probably back out of this. But nope, here we are.
You made reference to a key being found. Did you yourself find that key?
No, I did not.
Were you at the scene where the key was found at the time it was found?
No, I was not.
So it'd be fair to say that you were told that a key was found.
Yes, I was told that a key was found.
Another checkmate. There it is.
So it'd be fair to say that you went off of what you were told. You actually didn't observe this with your own eyes.
What are you speaking of?
The key being found.
That's correct. I was told by two officers who I've worked with for a long time, and I trust what they tell me to be accurate.
You made reference to there being a couple, was the word you used, a couple ways to identify individuals, and you stated that you had spoken with the mothers of the alleged defendant's children. That be fair to say?
I believe I said I spoke with the mother of 3 of your children.
At that time, was the alleged defendant already in custody?
Yes, he was.
Wouldn't it have been easier to just use the fingerprints that were already obtained?
Like I said before, the fingerprints was one way. We also verified it talking to his family members that his identity.
Any reason why, or let me back up. Is it fair to say that there was more confirmation needed to identify the alleged defendant at that point, seeing as how the fingerprints were already obtained?
We were just being thorough. We were certain that it was Darrell Brooks that we had in custody based on his fingerprints and other information that we had. It was just a matter of being thorough and verifying the person that we had and the name that he goes by.
Right.
It'd be fair to say fingerprints are pretty accurate, though, correct? Would that be fair to say?
I think that would be fair to say.
So it would also be fair to say that there wouldn't be any reason why the alleged defendant that was in custody would be someone else. Wouldn't that be fair to say?
Objection, that's compound and difficult to follow.
This is not compound. This is not
Sustained as to the
difficult to
form
follow.
of the question, sir. Please
That was
rephrase.
very clear.
Sustained as to the form of the question.
And where did the interviewing of the mothers of these children take place, if you recall?
I spoke to Jessica Macklin in Iowa at her residence. I spoke to Angel Fitzpatrick at her residence in Menominee Falls.
Whoa. Can we strike that? Why do the names?
You asked the
stated?
question.
Overruled, he was answering the question. His
He
answer
didn't
may stand,
specify.
your request to strike is denied, and the witness may continue answering.
I spoke to Angel Fitzpatrick in Menominee Falls at her residence, and I spoke to Erica Patterson a number of times at various locations about you.
You said one of the mothers of these children you spoke to in Iowa.
Correct.
Why would you go all the way to Iowa?
Because initially you listed her as a witness on your witness list for court. So we went there and we wanted to verify what information she might have that she would testify to.
Just for the record, I don't recall listing anyone as a witness, just for the record.
For the record, Mr. Brooks, you can't testify at this
know
moment.
that.
You'll have an opportunity should you choose.
I just wanted that clear for the record since what was
Can't be,
said.
it's struck from the record at this point because you're attempting to testify.
When he does this, though, okay, he didn't directly say, like, oh, yeah, those are the mother of my children. Even in that little moment that, he was testifying, but he never said, oh, I don't know those women. The only thing he had to say was, I never called for anybody to come here or something like that. So at least the jury heard it. I mean, it's going to be struck from the record, but once again, I'm glad the jury heard it.
The jury will disregard that.
I just wanted the record to show
The
that
jury
I had no
will
knowledge of doing that. And if
The jury will disregard those statements made by the defendant
If
as
something's-
that he is not testifying, and it would be improper at this time for the court to receive
She's
them.
stuck looking
I
at
don't
the
think
ceiling.
record should be
Next
made of
question, sir.
Something that I didn't do.
Next question, sir.
It's ridiculous. So you said you went to Iowa to try to find out what would be testified to. Why?
Objection, argumentative,
Grounds.
irrelevant, and calls for hearsay.
Grounds.
Sustained as to all basis. Next question.
Was that an attempt to prepare for what might have been said?
I'll allow that.
Okay.
Go ahead.
Yes.
Why would there be preparation involved in someone who might testify on an alleged defendant's behalf?
Objection, argumentative.
Grounds.
Overruled, I'll allow it.
We went there to speak with her, so if she came and testified, there wouldn't be any surprises. We also wanted to find out if there's any background information that she had about Mr. Brooks that would be helpful in our investigation.
I know he's going to be mad about that. Why would you need to prepare, though?
So you made reference to not being any surprises. Would it be fair to say that there was a little worry there?
Objection, argumentative.
Grounds.
Sustained as to the form of the question.
I don't know if you noticed that, but
Good.
even attorney Zach, he couldn't help but like smirk from that. Is he trying to insinuate like the prosecution was worried about him and that he might actually put up a fight that they can't they can't handle or something? Okay, let me stop pausing.
What surprises were you referring to? What do you mean by surprises? No surprises.
Your Honor, I object to this entire line of questioning. This witness is not expected to testify. It's wholly irrelevant.
Well, he opened the door by putting the name on the record and saying where you went.
I will allow one more question on this. Go ahead, you may answer.
Could you re-ask the question, please?
What do you mean by making sure that there were no surprises?
We wanted to make sure that there wasn't any information that we weren't aware of that may come up later that would be helpful in the trial.
Do you recall making an attempt to interview the child
Objection, relevance.
who was 7 at the time?
Sustained as to... Next question, please.
And he knows the age.
Reason for the sustain, Your Honor?
Not relevant.
Well, the question was asked, does he recall?
Sustained. Next question, please.
Grounds for the sustain again?
Relevant.
How is it not relevant?
Keep going, sir.
Did you interview the child?
Same objection.
Grounds.
Sustained.
Grounds for the sustain?
Relevant.
Why would you ask to interview the child?
Your Honor, objection. This
Sustained.
entire line of questioning is inappropriate.
Sustained. Move on.
I would
Mr. Brooks.
object that trying to interview a 7-year-old child is...
Sir, move on, please. 90611. It's also not relevant. Assumes
very
facts not in
relevant.
evidence.
It was a tricky move.
And how do you know that? How I wish so badly they could ask him questions. I know they can't.
You made reference to, in regards to Exhibit 88 and 89, which were documents from an entirely different county. Do you work for Milwaukee County?
No, I do not.
So how did Milwaukee County, which is a different county, come into your investigation in Waukesha County?
You may answer.
Detective
Oh.
Casey is
With
hilarious.
the understanding there are some limited pretrial rulings that still are in play. Go ahead.
During the normal...
I'm sorry for interrupting. I started off by saying in regards to Exhibit 88 and 89. That's how I started the question, just for the record.
I know. I'm reminding the witness of the pretrial rulings.
Okay.
During the normal course of an investigation, we do background on a person to see if they have any open cases or any information that would be helpful. There is a computer system that displays what cases or charges are open for a person, and it is relevant because if you are charged in one county and you violate conditions of bail, you can also be charged in another county for those violations.
And in reference to charges in one county and potentially being charged in another county, in reference to that, wouldn't you essentially have to violate the conditions in one county and strictly be charged in that county?
That is an inaccurate statement.
Who taught him how the law works? This is insane how he believes everything works. It makes no sense at all.
You being in law enforcement for a very long time, it would be fair to say that you're familiar with the term double jeopardy, right?
I've heard the term before.
And what is your understanding of what that term means?
Objection, irrelevant, beyond the
Grounds.
scope of the witness's knowledge, legal conclusion.
Sustained for all those reasons.
Okay, before I speak on that, let me look this up.
So when did you become the lead investigator in this matter?
That was about 8:30 p.m. on November 21st, 2021.
So same night.
Correct.
And whom were you made lead investigator by?
The command staff or Lieutenant Jerry Habanik.
Do you recall why you were tapped to be the lead investigator?
Because I was the most qualified person and had the most experience to take care of it. That's what I've been told.
Any other reasons besides that?
Also because I was at the parade route a little bit earlier and I had the most information out of anyone. It took a little while for the other staff to come in, so I already had a little bit of a head start with the information that I already had learned as being there at the beginning.
And that would be the information that you said you had more knowledge of than anyone else at that time. Would that be in reference to having an interaction with the vehicle at some point?
I would say as the totality of the situation. I was there when the car first went through. I know what the radio traffic was for taking Mr. Brooks into custody. There's also some decisions that were made early on how to proceed with the case. I was also on scene downtown and took control of the crime scene initially. So a lot of those decisions were made even before our command staff started coming in to take over lead on the case.
When you referenced you were there at the beginning when the vehicle first entered in the parade. What do you recall about when the vehicle first entered the parade?
I remember a horn beeping, red Ford Escape driving around, and then you driving into me and not stopping when I pounded on your hood and window.
Driving into you, what do you mean?
I meant that I was in front of your vehicle contacted me, pushed me off to the side, and continued driving without stopping.
Were you injured in this incident?
I was not injured, thankfully.
And you made reference to a horn beeping. What do you mean a horn beeping?
I mean,
The vehicle was beeping its horn?
Yes, the vehicle was beeping its horn.
What would be the only time a vehicle would beep their horn?
Objection, speculation.
Grounds.
Sustained. Calls for
Reason.
speculation.
Okay, and really quick, so I looked up double jeopardy, and the meaning is the clause provides that no person can be convicted twice of the same offense. Okay, now understanding that's what it means now, that makes no sense in the context that he was trying to put it in. I mean, that's not even something that's happening right now, so I don't really know why he even mentioned this. And I was just gonna say, or I kind of briefly touched on it, but who taught him how the law works at all? Like, thank you so much to Mary S, I think, I believe is your name. She sent me an email with a link to a video about the miseducation of Darrell Brooks, and I'll probably put a link to it down in the description if you all want to check it out. But I looked at it and it explained a lot of the sovereign citizen stuff that not only Darrell Brooks believes, but just in general. Like, I had no idea how deep the rabbit hole goes with all of these beliefs that they have and how they don't really believe any law whatsoever applies to them. But I'll definitely put it down in the description if you all want to check it out. Like, it's very interesting, especially if you want to understand how sovereign citizens think, and just to have more details on like the stuff that Darrell is saying. Yeah.
Do you know why the vehicle was beeping their horn?
Same objection, Your Honor.
Do you know why you would beep
He
your
asked,
horn?
do you know why? So he can answer that question.
Could you repeat the question, please?
Do you know why the vehicle was beeping its horn?
I imagine that the driver was angry and wanted to get through the crowd.
And how did you come to that determination?
I've been driving a long time, and a lot of times people get angry, they're late, they beep their horn at you in a way that is because they're upset and they're trying to get past you.
Do you know that for sure?
You asked me my opinion.
Yes, I did ask your opinion. Now I'm asking you, do you know for sure if the driver of the vehicle you observed was in fact angry?
I assume that he was.
So it would be fair to say you don't know for sure.
I do not know for sure, but that is my opinion, is that he was angry.
And at that time, you had no knowledge who the driver was. Would that be fair to say?
Well, I had knowledge because I saw your face. I did not know your name
Did
at
you
that
know
time.
who the driver was? No, meaning had you had any prior interactions with them before this incident? That's what I mean by no. Have you had any conversations with him, talked to him?
Hold
saw
on.
him?
Compound question. Ask one.
I was just giving clarification of no,
You
what I
need to,
meant by
it's
no.
a compound question. Please rephrase.
Before you observed this vehicle, as you say, this driver as you say, did you know them?
I have no memory of meeting Mr. Brooks before that afternoon.
So it'd be fair to say that you're assuming something that you don't know. Would that be fair to say?
Objection, compound, vague, and argumentative.
Sustained.
Grounds?
Sustained as to the form of the question.
He is breaking. He's
How would
breaking
you know how
mentally.
someone's feeling
He's already
if
broken.
you don't know who they are?
Your Honor, he opened the door to this. It's asked and answered. The witness has given his opinion. It's clear.
Grounds?
I object. Improper question.
Grounds?
I will allow the witness to answer why he came to that conclusion. Go ahead.
Like I said before, I've been driving a long time, and a lot of times when people are beeping their horns, it's because they're late, they're angry at something happened, and that's why I concluded that the person was probably angry.
So would it be fair to say that another reason why a vehicle would beep its horn would be to alert people to the presence?
Well, okay, before he answers that, I'll go ahead and answer it. No, it's not fair to say, because you literally hit people and then you kept going. So I think that idea is out of the window to say that you just wanted to alert people that you were on the way. That's completely out the window.
Objection,
Grounds?
irrelevant, speculation.
Grounds?
I'll allow it. Based upon his training and experience, he may answer.
It's a possibility.
There you go, Darrell.
And did you hear this beeping before the vehicle approached you?
Yes, I did.
He better not say, why didn't you get out of the way? Oh my goodness, he's gonna say something really stupid right now. It's coming.
You made reference to And I'm referring to the ring video obtained in exhibits 88, or I'm sorry, the ring video obtained in exhibits 13 and 14. You made reference to obtaining that the same night of the incident. Do you recall saying that?
Yes, I recall saying that.
And it would be fair to say that you yourself have been present for all testimony. Would that be fair to say?
That is not correct.
How so?
I was sick one day and I was not here.
Well, I'm referring to, let me clarify. Maybe I wasn't clear enough. Pertaining to all testimony since trial began, you've been present for all testimony. Would that be fair to say?
I believe I've seen most of it.
Do you recall testimony of and I'm referring to, again, so clear for the record, exhibits 13 and 14, ring footage that was obtained by the owner of 4014 North 19th Street, that you testified to obtaining the ring footage the same night. Were you aware that, well, let me back up just a little bit.
What is
How were you able to obtain that ring footage?
There was officers that went to Freighter Hospital where Dawn Woods, Mr. Brooks' mother, was working. They spoke to her.
What?
And she's the one that alerted to them that she had ring video at the house and offered to remotely download that video for them.
And
So wait a second. Okay, no. I remember somebody telling me this in the comments. I completely forgot. His mom works at the hospital. And I do remember somebody, so many details get... Okay, so I learned so many new things about like what's going on. That's one of the things that I'm sure like I probably wrote it down somewhere, but so was his mom at the hospital during the time where like all the victims were being rushed in? And because I know people also told me that like his mom, she was very cooperative when it came to like just offering this information. And I believe she also called and said that her SUV was stolen or something, like right after she saw on the news that Darrell had done after he ran through the parade. But that is so crazy. I don't know what job she has
you
there.
there
but-
yourself?
I was not there myself.
When did you yourself speak to the owner of that home?
The last time that I spoke to Dawn Woods was on August 8th of this year. I may have spoken to her a few times before that. I don't recall the exact dates.
I'm referring to the first time that you spoke.
I don't
The
recall
very first time.
I don't recall the first date when that was.
And you did just make reference to an August 8th date. And what was the extent of that conversation?
Objection calls for hearsay.
Grounds?
Sustained. Hearsay.
He loves hearsay.
The August 8th date that you referred to, was that in any way follow-up? Was that follow-up investigation?
Follow up to what?
Well, you stated that you had spoken previously before the August 8th date. So the question is, was the August 8th date follow-up to the investigation that you were already actively lead of?
I mean, everything is related to this investigation. The
So-
investigation continues every day. It will not end until this trial is over.
What was the point of even asking?
So
that?
follow-up was needed at the time of the August 8th interview. I'm guessing that's what you would call it. I don't know, I'm not sure.
Objection still calls for hearsay, Your Honor.
Sustained.
Why did you need to talk to Miss Woods multiple times?
Because every time we spoke to her, we got different information, and at that time we were following up with your niece and nephew of what their testimony would be in this case.
What testimony are you referring to? Because
My niece and nephew aren't here. Are you gonna say it?
I don't recall any nieces or nephews testifying.
I don't think I'm allowed to say it.
I think this line of questioning is irrelevant, Your Honor.
I'll sustain the objection, and at an appropriate break, I can address it further if need be. Please move on to a new topic, sir.
Just end the cross-exam altogether, because this is getting ridiculous now. I mean, it started off ridiculous, but there are so many people he should just never even speak to them. He should have stayed as far away from Detective Casey as he possibly could.
You made reference to people who were injured at the parade inadvertently. You recall that?
Yes, I do.
Oh, no.
To your knowledge, were any of those charged?
My testimony before is that those people's cases were not charged.
And were they seen as victims?
Going to object to the form of that question. I think it calls for a legal conclusion, Your Honor.
It does not. I asked to his knowledge.
I'll sustain the objection as to the form of the question, if you could please rephrase.
I thought he was going to ask something way more, like, disgusting. When it came to, every time he mentions, like, the victims and stuff, it's like I get chills down my neck. I don't know what he's going to say. He usually says something really horrible, though.
I'm going to go a different route.
Please do. Go the end the cross-exam route. That's the best way to go.
Do you recall serving a warrant to the Waukesha County Jail on July 1st of 2022?
Yes, I do.
Do you recall what that was for?
Yes, I do.
And what was that for? Can you state for the record and for the jury?
It's for Mr. Brooks's jail cell.
Oh, okay.
And why did you serve a warrant for a jail cell?
Your Honor, I object pursuant to legal rulings previously issued in this case. I don't think this is relevant.
I'll sustain the objection. It's not relevant. I'll certainly take it up at a later point if need be.
What was the warrant pursuant to?
I sustain the objection. Next topic, please.
He did answer.
I sustain the state's objection. I'm directing him not to answer. We'll take it up separately. I'll have you continue with your cross-exam, and I'll take it up later.
Hold on. He might get frustrated and end it here. He might just end it. Because I don't know if you all have noticed this too, but whenever Judge Darrell, like, he feels as if she's interrupting him or something a lot, he'll just go ahead and end it, and he feels like that's a punishment to her or something. As if, like, well, you can't hear me ask the rest of my stupid questions anymore. I'm not gonna ask him anymore because you kept interrupting me. It's like, dude, you're not punishing anybody. Thank you.
You made reference to this vehicle driving into you, but stated you were not injured. Did you file a claim in this matter?
No, I did not.
Do you consider yourself an injured party in this matter?
No, I do not.
Do you yourself know if anyone filed a claim in this matter?
Can you be more specific?
Do you yourself know if anyone filed a claim in this matter?
You just repeated the same question. Okay.
Just in general?
Whatever your interpretation of that will be.
I would say yes.
And do you know what that claim was?
I would imagine that there was a lot of injuries from the people. A lot of people had very extensive medical bills. And I imagine that they would file a claim with their insurance company to have those bills paid.
So you had knowledge of what was filed to their particular insurance companies?
I have no knowledge, but my assumption is that they would have filed those bills.
So it would be fair to say you don't know for sure.
That was my testimony.
Is that the answer?
Yes.
As lead investigator for this matter, are you, to your knowledge, aware of any GoFundMe type of things?
Oh no.
Objection relevant? I'm sorry.
Do you mean as it relates to?
As it relates to the incident.
Overruled, the witness may answer.
I have no direct knowledge, but I assume that there are some GoFundMe pages out there. It's typical in something like this.
And what do you mean by typical? You've seen this before? Is that what you mean by typical?
We have a very loving and caring community where a lot of times when bad things happen to people, people pull together and offer financial assistance to help people.
Is it fair to say that there's a lot of communities like that across Wisconsin?
I'm so serious. This is
Yes, I think there are.
every time. Every time.
And it would be fair to say that you've worked extremely close with the district attorney's office during the entirety of this matter. Would that be fair to say?
The district attorney's office has been involved in this investigation since the night of, so we have worked closely.
So would it be fair to say extremely close, seeing as how you've been present for the whole trial pretty much?
Can you define extremely for me?
I would like you to define it. Extremely.
I'll answer yes if that helps.
Okay, I see now why everybody wanted me to see Detective Casey's.
To your knowledge, do you know if it's typical for a lead investigator to sit right behind the prosecution table at a trial?
Yes, it's very typical. It happens in most larger cases, especially a case of this magnitude. There would be a court officer. So yes, that's a very typical thing that happens.
Have you ever done this before?
I've done this multiple times before.
And are you the only detective in the investigation that has that honor?
Objection vague.
Grounds.
Sustained as to the form of the question.
Are you the only detective directly involved in an investigation that sits with the prosecution?
Talking about this case or any case?
This particular
or-
case.
I'm sorry, you interrupted me. Could you repeat that, please?
I believe he said this case.
I'm referring to this case, yes.
Could you re-ask the question, please?
Are you the only detective actively involved in this investigation
In the cross-exam, Darrell.
that sits with the prosecution in
Yeah.
reference to this case?
Yes, I'm the only person, the only detective that's sitting with the prosecution during this trial.
So would you explain who the other officer is in the blue suit over there?
Objection to the relevance, Your Honor.
Grounds.
Sustained.
I just want to know his role.
Sustained. Next
Reason
question,
for the
please.
sustain.
Not relevant.
He's been in the courtroom the whole trial. How is it not relevant?
Mr. Brooks, next question, please.
Nobody knows who he is. That should be known. Nobody said
It's
that.
not relevant to the issues that the
jury.
jury needs to determine. Next question, sir.
Is it asking? We're telling.
She's telling you. Oh my gosh. Can we kick him out now?
I'm assuming that's asking.
Can we kick him out now? Oh my goodness. Please. Please. I wish so badly.
Do you have a question, sir?
Yeah, I do. I would like to get to it. Thank you.
Please do so. Thank you.
I will.
Please end this cross-exam. Oh my gosh, right there. It would have been so satisfying if she would have just ended it right there. You know what? Let's clear everybody out of the courtroom and let's get this situated here. Because this is not going to continue. We're going to go ahead and get you set up in there with the nice little baby bottle that you so desperately want. You man-child, you.
So seeing as how you sat with the prosecution for the entirety of this matter, it would be fair to assume that you know who the plaintiff is in this matter.
Yes, I do.
And who would the plaintiff be in this matter?
The state of Wisconsin.
Is that an entity or a living human being?
It's an entity.
How can an entity file a claim?
Objection.
Grounds.
Legal conclusion.
Grounds.
Sustained.
You are aware that only a living, breathing human being can actually file a claim. An entity cannot walk into anywhere and file a claim if it's not even a real person.
Not true.
Objection.
You are
Move to
aware of
strike.
that, right?
Go ahead, Attorney Epper.
Move to strike the statements by Mr. Brooks. Also object to the question that was asked at the end as irrelevant, argumentative, and calling for a legal conclusion.
Objection is not calling for a legal conclusion in any way.
The court sustains the objection. The request to strike the statements made by Mr. Brooks are granted, or the request is granted. The jury will disregard the statement and the question asked for all of the reasons indicated by the stated also as a misstatement of the law.
No, I definitely object to that, Your Honor.
Your objection is noted. I'm going to
I'll
have
take-
the jury stand for a second. They've been sitting for quite some time, and then you can formulate your next question.
I take exception to that ruling.
The timing couldn't have been better for that too. He was trying.
And would
Listen,
like a legal finding of fact.
Your objection is noted. It's overruled.
it was so dismissive too for her to.
That's
I
a
look.
judicial determination.
We're busy stretching. We're not gonna acknowledge
Be
this.
seated. Go ahead, Mr. Brooks. Please continue with your questioning.
Is he gonna actually cry right now? He's looking like he actually wants to cry.
Have you ever had any interactions with this entity, state of Wisconsin?
Mr. Brooks, under 90611, I'm not going to allow the witness to answer. It's vague.
There was no objection.
Under 90611, I shall exercise reasonable control over the mode and order of interrogating witnesses. Please, next topic. These questions we addressed during the initial cross-examination of this
They're
witness.
going to keep coming up.
And I determined at that time that they weren't relevant. So next topic,
They're going to
please.
keep coming up.
And they'll keep getting
Under 90611,
shot
sir,
down each
please
time.
move on to a new topic.
They're going to keep coming up.
For the cross-examination, I will end.
Do you see the state of Wisconsin present in the courtroom today?
Objection, argumentative,
Grounds.
irrelevant.
Sustained. Final warning, sir. Next topic or the cross-examination, I will
You
bring it to
don't
an
got to
end.
keep. You don't got to keep doing that, Your Honor. You don't got to keep doing that.
It's my responsibility, sir, over this trial.
I'm informed. And
Thank you.
And I
Next
respect
topic.
that. But it's relevant for the jury to know the truth.
Oh my goodness.
They deserve to know the truth.
Move to strike, Your Honor.
Granted, the jury will disregard
Regret.
those last statements. They're
Objection
not
to that.
relevant. Mr. Brooks is not testifying. They misstate the law.
I object to that. That's not lawful law. And it's
Noted.
untruthful.
All right, under 90611, I am now stopping
Yes.
the cross-examination. Any redirect by the state?
Yes.
Objection to that. And I would like
Noted.
legal finding of fact.
Attorney Opera, any redirect?
Yes, just very briefly, Your Honor, I would like to display for the
Jeez.
witness only Exhibit 178.
Objection.
I haven't seen the exhibit yet, so I'll take it under
I'm
advisement.
objecting still because the
You may show it to the witness.
there needs to be an answer to why the jury's not being told information that they deserve to know.
Okay, we definitely can kick him out now, right?
Go ahead,
now
Attorney
he,
Opera.
Your Honor, for the record, this is a video. I'm going to play about the first 5 or 10 seconds for the witness to identify it before moving on, please.
And this seems objection because this seems like a whole new exhibit. This was never mentioned before. It was never.
I haven't seen it. I can't rule on it, sir, so let me
I mean,
see it, and I'll
when
take
did
your
it become an
objection
exhibit?
under, I'll
It
take the
was never an
objection
exhibit
under
before.
advisement. Go ahead.
I haven't seen this in any of the exhibits that I have. So how could it just be created now and be made an exhibit?
Go ahead,
I
Attorney
have
Opera.
all the exhibits.
Go ahead, Attorney Opera. I haven't seen it yet. There's
you don't
nothing
have
else
any
in
of the
there.
exhibits. They provided them for you.
See, it's now playing.
So now we just creating exhibits now. I have all the exhibits, and this was never in it. Oh man.
All right, you can stop. Sir, do you recognize what's contained in State's Exhibit 178?
Objection.
Overruled.
Relevancy.
Overruled.
Leading.
Go ahead and answer.
Yes, I do.
What is it?
Objection. Leading.
Overruled. The witness may answer.
I'm still going to object. How is this?
Mr. Brooks, I ask that you
Please kick him
honor
out.
the ruling that
I
I've
have
been
all the
made.
exhibits, though, Your Honor. I have them
Mr.
all.
Brooks.
They were provided to me, and this was never in the exhibit. So how could it just be made an exhibit?
I'll take
just
this
out
up
of the blue?
outside the presence of the jury, but I'm going to allow it.
Can that be stated for the record? Can that be explained?
No, the jury will disregard the statements made by Mr. Brooks. They're not evidence, and the statement
So this
continue.
exhibit shouldn't be evidence then, because it
Mr.
didn't
Brooks, the
exist before
objection's
today.
noted. It's overruled. Go ahead.
There was a still photo shown before of Mr. Brooks
This is
standing
mine.
in front of the Ford Escape. This is the video in which that still photo was taken from.
You could-
Objection. How does he know that?
Overruled. The witness may answer. I'll give you the opportunity to question him about it when the state's done asking the questions. Go ahead.
Where'd you get this video from, sir?
Objection. Leading.
Overruled. The witness may answer.
From Mr. Brooks' social media account.
Okay. Your Honor, move to admit 178 and permission to publish.
Objection to the relevancy.
I'll
And
find that
still
it's
don't know how
relevant.
it's
I'll receive
obtained.
Exhibit 168. Permission to publish is granted. For the record.
It's
Could you
178, Your Honor.
No, could you please tell me the length of the video?
The length is 2 minutes, 33 seconds.
Look at these
We're going
cartoonish
to
facial
play it
expressions
in
again.
its entirety,
His mind
but
is
without
breaking.
volume, Your Honor.
All right, thank you.
The closer we're getting to the end.
And,
I object to that, and I would like to make an offer of proof for my appeal.
We'll do that outside the presence of the jury, but I will allow the state to play it in its entirety without audio.
Your Honor, I have all the
Offer proof
exhibits
for my
that were
appeal.
provided.
Mr. Brooks, I'll take that up along with the other two issues I still need to address.
But how can you play something that I didn't even
Mr. Brooks,
have?
I'll take that up outside the presence of the jury.
This
Your
is
objections are
mind-boggling.
noted.
This is
It's
mind-boggling.
overruled.
Mind-boggling.
It's
actually,
definitely
Your Honor,
mind-boggling.
I changed my mind. I would like to play the audio, please.
This is mind-boggling.
I want to have it played first without.
I don't know if that's
and I'll
something
make
he
a
learned
ruling,
in
I'll
jail
take
as
that up.
well. It's like a new term that he's learned. It's mind-boggling.
Thank you.
So we will play the entire video, Your Honor, 2 minutes, 33 seconds.
I object to that. Why does the whole video need to be played?
Oh no, we're watching his
Is
music
this setting the
video.
Foundation?
It's relevant. You questioned the officer about it. You
I
questioned this
question him
detective
about.
about
I
his
question him
knowledge.
about the steel frame. From
He's
the video.
freaking out. This
The
looks.
video wasn't even in the exhibits that I received. I actually didn't even receive them. They
Mr.
were
Brooks, please
obtained.
stop. The
He's
durable
freaking out now that this
statements
trash is
do
getting
not
put
have
on
to
the
run.
screen.
The
Look at
video is
this.
playing.
Thank God there's no volume. And there's the dude he tried to throw under the bus.
So play the sound. I want to hear it now.
I'll address
See,
that.
initially I was laughing at it because it looks stupid, but now I'm just upset again because play the sound, now I want to listen to it. He finds a way to make it to where it's like, okay, this is hilarious to look at, and then he just turns it into full disrespect like that. But
We address why it was created out of the Bluetooth.
we don't want to hear this. We definitely don't need to hear this. $178. He's dancing in front of the SUV. I like how he's dancing in front of the SUV as if it's like a Ferrari or something, like a what's the expensive car brand. He's dancing in front of his
Go ahead,
SUV
Attorney,
though.
after the video is
It's
finished
Ford
playing.
Escape.
Thank you. Sir, did you see during the playing of that video the image that was captured as a screenshot and presented to you in your direct testimony as State's Exhibit number 175?
Objection leading.
Overruled foundational. The witness may answer.
Yes, I
A lot of
You were questioned on cross-examination as to your ability to identify Mr. Brooks in Exhibit 175, correct?
Objection. That question was asked initially by Attorney Hopper.
Overruled. The
Yeah.
witness may answer. Sorry.
Yes, I was.
As you just watched the entire video again now in court, as State's Exhibit 178, did you clearly see Mr. Brooks in that video, sir?
Objection leading.
Overruled. The witness may answer.
I believe there's no doubt that that's Mr. Brooks in the video and later standing next to the Ford Escape.
Thank you. I don't have any other questions, Your Honor.
As to this particular piece of evidence only, Mr. Brooks, you may ask questions of Detective Casey.
Objection, I don't consent to being called that name. And yeah,
Noted.
I
Do you
got
have any questions for the witness?
This, when did this video, when was this made a exhibit? Because I don't have it.
Objection, that's not a question for the witness, Your Honor.
That
Sustained.
was a question. When was
Sustained.
this
As to the
video
form
made
of
an
the
exhibit?
question,
When was this video
His
made
mind is
an
officially
exhibit?
broken.
That is a question.
I object to the question directed at the witness, Your Honor. It's beyond the scope of his knowledge.
sustained.
Well, he said he saw it.
But that's not the question asked. So you can rephrase your question if you want to.
When did you see this exhibit? When did you see it?
With the understanding that you're asking when did he see the video, I will
When
allow
did
the
you see
question
this
to be
exhibit?
asked. With that understanding, you may answer Detective Casey.
Am I answering when I saw the video for the first time?
Yes.
Objection, Your Honor. Why is something always funny at that table?
I-
It would be the same thing. I'll take that.
How is this not funny? I'm pretty sure I've reacted to this part before. Okay, sorry to pause so early because I know he's going to throw a tantrum here. But how is this not funny? You are an entire clown, sir. This is a clown show. How could we not chuckle at you from
I'll
time
take
to
that as
time?
disrespect because they were allowed to say something and I said under my breath that was disrespect.
I
They
would
just
direct
did the
both
same
parties
thing.
to avoid commentary.
Okay, well, can
and
you do that,
gestures
please, and
faces.
admonish them?
Yes,
Because
I
I'm
will.
always the one getting
Absolutely.
admonished.
Everyone.
I take that as disrespect too.
Sir, can I do my job? State's directed to avoid laughing commentary. I didn't see it, so I can't further comment. I was looking at
All these
the
cameras
witness.
in here, don't nobody
However,
never see nothing.
I'm advising both parties to show
Come on, man,
decorum
this is not fair.
and restraint, to be
I'm with-
respectful of this jury's time and attention, and to let them do their job by focusing on the testimony and exhibits and evidence that's presented. Go ahead, Detective Casey, you can answer the question about when you have seen this video prior to today.
I saw the video within a few days of Mr. Brooks being arrested. I've reviewed it since then a few times. I reviewed it yesterday.
Now he just
and
looks like
again
he wants
this
to
morning,
cry.
And now in court again.
You said you reviewed it yesterday and this morning. If you had seen this video numerous times before yesterday and today, why did you feel the need to view it yesterday and today?
Objection, argumentative.
Grounds.
Sustained as to the form of the question.
Why did you need to review it this morning?
Objection, argumentative.
Overruled, the witness may answer.
Because I wanted to be 100% sure of the content, and if there's any questions that were asked of it, I wanted to make sure that I would be able to answer them appropriately.
And why was this, to your knowledge, why was this video never brought up in your earlier testimony?
Objection, that's a
Grounds.
misstatement, Your Honor.
Sustained
it was
as to the
not
form
brought
of
up
the
in the
question
earlier
assumes
testimony.
facts not in evidence.
If you have seen it numerous times before today, why did you need to see it again to make sure if any questions were asked, or however you refer to it? What would be the need to view again this morning
Oh, man.
something that you had viewed numerous times before?
I'll stay with my
Objection,
Hold on.
objection, compound, asked and answered, misstatement of the facts, argumentative.
Sustained.
He's going to throw a tantrum. He wants them to just let him do whatever he
You viewed the video
wants.
this morning because you knew that the video would be made an exhibit this morning?
Objection, assumes facts not in evidence.
Sustained as to the form of the question.
This is mine.
There he goes with mind-boggling again. I'm telling you, he learned this in jail or something. Somebody told him this because he can't stop saying it.
Can you clarify again why you viewed the video this morning?
Objection, asked and answered.
Sustained.
So you're going to sustain everything?
It was already answered, sir. Next question, please.
And I'm asking for clarification.
Next question, please.
I don't got no more questions, man.
Yes.
Thank you.
This is mind-boggling.
Detective, you may step down now.
It is
Excuse the
mind-boggling,
jury.
but I'm so
What you're trying to
happy.
do is not fair. Hide things from the jury repeatedly. You don't tell them all the information
Mr.
they
Brooks,
need
I'm
to
going
know.
to take up all of your objections outside the presence of the jury. I'd ask that you honor my decision to do that, and you show courtesy and decorum.
Because you asked.
Mr. Brooks, please.
Because you asked.
Whatever.
That's the only reason, because you asked.
But okay, how can he not find this hilarious? Like, he's making a complete and total fool of himself right now. The fact that the prosecution has been able to contain their laughter for this long, like I've seen moments where they're chuckling, but I don't know how they just don't break out like laughing hysterically at some of these moments that he has like this. So he should really take it as respect at the fact that they're not laughing at him at the top of their like just screaming laughing, because this is ridiculous, man. This is a clown show.
I see what you people are trying to do. It's not right. It's not fair and it's not right.
I think we're gonna see him get kicked out today.
You can have a seat. Well, once the jury's outside of the courtroom, I'll take up the objections previously in the evidence. All right. First of all, Attorney Hopper, if you can make a record as to this exhibit and whether it's been turned over previously.
It was previously included in the initial discovery that was sent initially to the public defender's office, and now we have a record that those 3 boxes were turned over to Mr. Brooks.
Objection, I don't consent to being called that name, and it was not in the video footage that I have obtained. That video was not part of it. Do you think I would sit here and be this irritated?
Mr.
by
Brooks, I need to
something that
make a
saw?
record, so just please sit down. There's no need for you to stand at the moment.
I feel like standing right now.
Please sit down.
I feel like standing.
All right,
I can
based
tell
on the
she's
offer
getting
of proof
irritated with
provided
this.
by the state, and it was provided to prior counsel, that satisfies me as to that issue.
That's
I
inaccurate.
indicated
That's
I would-
inaccurate, Your Honor. Can we have the prior counsel testify to that then? Because
Not at this time, sir.
I have not obtained that. Right now, that was my first time seeing that as an exhibit. That's
Mr.
why I
Brooks, I
raised the issue.
presume,
fault is
and you
that?
can correct me if I'm wrong, but you're familiar with that video? Yes or no?
What does that have to do with what we're talking
Because
about?
I'm going to make a finding based upon what I viewed in that video, that there is absolutely no surprise to you. It appears to me, even without the video, that that's a music video, that you are in it, that the vehicle that has been the subject of this entire case, that red Ford Escape with the plate that's been testified
Exactly.
to, is in that video. That video is relevant for a number of different reasons, the first of which it goes to identification of you, identification of the vehicle. You opened up the door through your cross-exam of Detective Casey about his ability to identify you in that video. And when I say identification of you, specifically as it relates to Detective Casey's opinion that that's you in the video, of course, it's ultimately up to the jury to determine that and what relevance, if any, that evidence have. But you opened up the door for the state to show that video.
Exactly.
Because you directly attacked the credibility of Detective Casey through his knowledge of it and the identification by him of you in it, because the still image was of your back.
Okay.
So that opened up the door, and it's proper. There's absolutely no surprise to you that that video exists, and that is my finding as it
What do you
relates to
mean by
that.
it's no surprise to me that it exists? That was not the issue. The issue
You're in
was
it,
how
dummy.
was it made an exhibit at the last moment? How does it be made an exhibit out of the blue? That was the issue. The issue
State can
didn't
make an
have
offer of
anything to
proof
do
on
with.
that, because obviously they marked it as an exhibit.
Well,
They
with
had
all
it,
respect,
so
Your
go ahead,
Honor, you're
Attorney Hopper.
mischaracterizing what I said, and the record needs to be clear. The issue that I raised was, how does this, at the last minute, out of the blue, become an exhibit?
Attorney
That
Hopper,
was the
go ahead
issue.
and make your offer of proof on that.
Thank you, Judge. And another thing worth noting is the testimony of Detective Casey that this video was obtained from the defendant's own Facebook account as well. The court is well
Objection.
aware.
He said social
There's
media. He
nothing
didn't
that
say what it
Hold on,
was.
sir, stop interrupting. We have to make a record of it. You've
Then make the record
interrupted multiple times. I've been abundantly patient
record
with
clear.
you. Again, another interruption. So you need to be quiet and let the state make a record. Stop gesturing
Are you asking
at
me to be quiet?
Stop rolling your eyes at me. Stop
I'm
mumbling.
looking right at you. I'm not rolling my eyes.
No, you
I'm
have
looking.
throughout. I've seen it
I'm
and
looking.
I've made note
I'm
of
looking
it.
at you. Okay, so are you asking me to be quiet or are you telling me to be quiet?
Please
ahead,
tell
Attorney
him.
Alford.
Please tell
Thank
him
you,
you're
Your Honor.
telling him.
Okay.
And just to indicate, Your Honor, this court has been abundantly patient with Mr. Brooks. He challenges the court's authority repeatedly. This court absolutely has the ability to tell him, sit down and be quiet. And you haven't done that. And I know why you haven't done that, Your Honor, and we appreciate that. He is not in control of this courtroom. You are. And he
Exactly.
needs to respect that. This video was relevant based on his questioning of Detective Casey, as you just indicated, challenging his ability to identify the person who had their back turned to the camera in the still shot of State's Exhibit 175. Trials are fluid. When he opened the door to that, we came up with the video which Detective Casey testified repeatedly on direct examination and cross-examination as to how he knew that was Mr. Brooks, because he had seen the rest of the video. He would not accept that. He pushed it and pushed it and pushed it until we played the video. The lyrics of that video probably would have been prejudicial. Originally, I wasn't going to ask for volume. Then I did, because he pushed it again, and his voice and his mannerism of speech, I thought, would have assisted the jury in identifying Mr. Brooks as the person in the video with the red SUV. However, you smartly asked me to play it without the audio, and I did that, and then I never went back to that. This is all to the benefit of this defendant, who continues to suggest and impugn the integrity of this court and this prosecution without basis. He doesn't like it because the evidence is stacking up and stacking up, and whenever it does, his response is to accuse you, the court, or the prosecutors of being unethical and hiding things. There is nothing.
And it's true. And I heard he did a little laugh in the background, because it's true. It hurts his little feelings, the fact that everything she's saying right now is the complete truth. And this is going to boil over into a really bad tantrum here in a second, I'm sure. But it's like, you can tell in his little world, or in his little mind or something, his actions have or should have no consequences, is what he believes. She's telling him right now, you pushed the issue, therefore we brought out this video. We weren't going to do it if you didn't push the issue. This isn't like I feel like he feels like a trial is just everything is set in one specific way and everything is just linear, when it's like, if you open the door to something, like they've done this numerous times where he pushes the issue on one thing, so now we have to go ahead and show the entire exhibit, or we have to show them every bit of evidence surrounding this topic that we have, because you won't stop. You won't just let them see the exhibits that you do know of. But yeah,
In law that prevents me from pulling something out of my briefcase right now and making it an exhibit if it's relevant. You decide what's relevant, what's admissible, not Mr. Brooks. There is no law, he can cite to no law, no authority whatsoever that says I can't make an exhibit essentially on the fly if it's called for, and that's exactly what just happened here. So I apologize for my tone with the court. I don't mean to direct this at the court. It is very frustrating. The court has demonstrated much more patience than I have with Mr. Brooks, because again, I do not appreciate his impugning the integrity of these proceedings, of Your Honor's efforts to run a fair trial, and of our efforts to run a fair trial. We have ethical obligations as well to be fair in this courtroom. We have respected that entirely. The reason I was laughing 30 seconds ago was because the exhibit was mislabeled. There was an extra Y and it said Exhibit E, EXHIBITY. And I turned around to the paralegal and pointed that out, and we laughed over it, the word exhibity. That was it. There has been no disrespect directed at Mr. Brooks directly in any fashion. So he can object all he wants, and he has made that clear. He will continue to object and obstruct the court and obstruct these proceedings every last chance he gets. But legally, everything has been above board and proper, and this exhibit is no exception.
Man, that is incredible. He should have never angered District Attorney Sue Opper. He should have never done this. He shouldn't have made her angry. That was wonderfully said. I'm not even going to add anything onto it because I can't add anything onto it. She summed up everything perfectly. But of course, Darrell's going to come at the end and pretend like none of this was ever said.
I apologize for my tone, Judge.
Thank you. I appreciate that additional record being made.
I object to that.
My previous ruling doesn't change in any way that the exhibit is relevant. I indicated I would take it up because, and I'm taking what the state's saying as withdrawing the request to play the lyrics.
That is correct.
All right. I have not heard them, but I'll certainly take the state at its word as an officer of the court that it would be prejudicial based upon the lyrics that are in that video, but my decision to admit the video without audio stands. I do want to take up two other issues. There was an objection to questions regarding cross-examination, so the objections were by the state. One had to do with there was questioning about possible testimony with his niece and nephew, and then the jail cell search issues. So Mr. Brooks, you asked the questions. The state had objected. Since you're the proponent of what would presumably come in through the testimony of Detective Casey, what is your offer of proof as to why I should allow Detective Casey to come back on the stand and testify about his interaction, I believe it was with your mom, and possible testimony of your niece and nephew?
It don't matter with Detective Casey. He's off the stand. He's not going back on the stand.
No, but I told you I would recall him. I wanted to take it up outside the presence of the jury.
How do I supposed to know?
He just wants to argue.
So are you withdrawing that, sir?
How am I supposed to know? I think I deserve a chance to rebut what was just said. I think I deserve that much if it's a fair trial.
You deserve nothing.
What information do you want to provide to me about that last exhibit?
About what last exhibit? I'm talking about the audacity of the prosecution to just put that on the record when it's stating it's untrue.
I don't know what you're talking about. What's untrue?
We just heard her talk for 5-10 minutes straight. Now don't nobody know what I'm talking about.
Because nothing was untrue about it.
What you're talking
there's a
about,
reference
sir.
made to what I'm supposed to know about the evidence stacking up and this and that, as if that has any bearing on what I still think and what I'm still going to present. It doesn't.
Well, that's not what we're talking about at the moment. I made a ruling on an
She's
exhibit.
been laughing and making comments under her breath the whole time during the whole trial, and I never said nothing. I don't know what's being said, but I can tell that it's directed towards me. I'm not an idiot.
I haven't made any of those observations,
I didn't
sir.
say
What
you.
I've observed,
I didn't say you, Your Honor.
No.
But
What I've
for
observed
her,
is
for her, listen, please.
Go ahead.
For her to sit there and try to play it off as if she's not referencing to me, she must think I'm an idiot.
Nobody
That is
said
very
sir.
disrespectful to me. I haven't said anything about that until today. She's done it numerous times.
What are you talking about? I don't know
Her
what you're
laughing
saying.
under her breath. Her trying to cover up the microphone so they can laugh and hee and key. That they've been doing that the whole time. I didn't say anything about it.
I have not noticed that. What I notice are 3 attorneys who cover up the microphone so that they're not heard when they're conferring with each other about evidentiary issues or about testimony.
So why is it always laughing and giggling?
I haven't noticed that other than the one thing you pointed out.
Well, we
today,
have cameras. That's what the cameras
Mr.
are for.
Let's refocus our attention on what we're here for, and that's
Okay,
this trial.
then I take that
do
as.
you have anything
I
you
take
want to
that
put on
as.
the record?
I'm putting it on the record if I get a chance.
No, you need to let me finish. As it relates to the video, and my decision to admit it.
She just admitted that she just now came with the exhibit. It was not, she just said, she just made it an exhibit. It
That
was
doesn't
not
mean
an
it wasn't
exhibit
turned
before she
over
made
to
it
you.
one.
So do you have some legal basis, sir, for your position? Because I'm not
What do
aware
I
of
need
any.
legal basis for when she just admitted on the record
goodness.
that she just made this exhibit up
No,
right
she
now?
didn't. That is a complete mischaracterization. Sure, she did not.
That's what. So she wasn't
Create
implying
the
that by saying that
exhibit.
she can
She did
pull
not make it
anything
up.
out of her suitcase.
So that's a figure of
During,
speech.
okay, so what is
All right.
it implying to? What would that be implying to?
As
How would
attorney-
anyone?
all
How
right,
would
I'm
anyone in
moving
my
on
position?
because you're not
How
providing me
would-
with any
how would
legal
any-
basis.
I didn't even finish.
For me
You
to,
told me that I can make the record. I'm attempting to make the
well,
record.
Sir, as it relates to the video and my decision to admit it, do you
I
have
just said
anything-
that you didn't even let me finish.
You're not letting me finish.
You didn't let me finish either, Your Honor.
Because you're not providing me.
But how do you-
rant,
how do you know I
you're
wouldn't get to
providing
that if I didn't
commentary,
finish?
You're not providing me with anything from a legal basis for which I would consider changing my mind. So the state's withdrawn their request to play the audio.
Then why play the video at all then?
I've already made a ruling on that. You're questioning the ruling. You're not asking me to reconsider it based on any legal basis.
There should be a legal reconsideration of it.
Then you need to provide me with the legal basis for that, sir.
So I'm supposed to just come off that with off the top of my head?
Yes.
No, okay, yeah, you can do it tomorrow, Darrell. You can take this project back to your jail cell and come back to us in a couple weeks and tell us. I guess that's how you think it works. This is insane. I'm not gonna pause it. I'm gonna let this tantrum run its course because, yeah.
That's ridiculous.
You're representing yourself. It's not ridiculous.
It is ridiculous. So I was supposed to already come in here this morning and say, oh, a video is going to be shown off the fly at the drop of a hat. Let me try to find some legal thing to combat. How am I supposed to do that?
The bottom line is you opened the door to
It
the
doesn't.
playing
It
of that
doesn't.
video.
We're not talking about
And the
opening
video
no
was
doors.
previously provided to you during discovery.
We're not talking about opening no doors. We're talking about being fair.
There's
Because
absolutely
if I
no
would have did
prejudice
that,
to
Your
you
Honor,
in
with all
terms
due
of
respect,
surprise.
with
by
all
the
due respect,
exhibit.
if I had
Right.
done that,
I am going to move on.
if
from
I
this
had done
topic.
that, it would have
Mr.
been a
Brooks,
big
I'm
thing.
advising you.
Are you
that
asking me?
I'm advising you, sir.
Oh, okay.
I'm
I don't know what that
advising you
means.
to sit down
I
and
don't
be
know what that
quiet.
means.
And if you interrupt me again, you are on notice that you will forfeit your right to be present
So
in
you're
this
holding me in
trial.
contempt
Mr.
for the
Brooks,
entire trial? Did you say the entire trial?
I never
Hopefully,
said any
I
such
You
wish
thing.
said for the
would.
trial. So what do
Please?
you mean? I'm asking, what do you mean?
Mr. Brooks, you continue to
That is
come at
not,
me.
I don't consent to being called
You
that name.
continue to fight with me.
I'm
You
not
are
fighting
being
with you.
disrespectful.
I'm not fighting with you. I'm not.
I'm
But
going to give
you
you
said I
one
would have
last
the chance to make the
opportunity to
record.
sit down and be quiet so I can make a finding
Are you
as it relates
asking
to
me
other
to do
things.
that? Are you asking me
I don't
to
need
do
to
that?
ask, I'm telling you.
Yes. Yes.
Thank you. There were two other issues that came up that I advised the parties I would take up outside the presence of the jury and give, if appropriate, Mr. Brooks the opportunity to ask further questions of Detective Casey. There was questioning by Mr. Brooks about possible testimony and why it had to do with it was in the context of him questioning Detective Casey about speaking with Dawn Woods, his mother, and about a time in August, and there was some reference to his niece and nephew. And I sustained the objection. I wanted to take it up outside the presence of the jury. That's the first issue. The second issue was the questioning of Detective Casey by Mr. Brooks related to the jail search. Do you want the opportunity to question Detective Casey about either one of these two topics is my first question.
Okay, why was it an issue with me bringing it?
Mr. Brooks, I'm only going to ask you one more time, and if you don't
I'm saying,
answer it
if I don't
correctly,
understand,
then
if I don't understand what was the problem in the get-go with the question, how am I supposed to answer it now?
All right,
Mr.
that's your
Brooks,
answer. We're done here.
Listen to me, please. I'm going to ask this question one more time.
Man,
It calls for
I don't
a yes or
I don't
no.
like your tone and the way you're talking to
It-
me. I don't.
Mr.
I don't
Brooks?
appreciate it.
Let's get him
Sit
a box
down.
of Kleenex.
I don't care if you
No,
don't like my
I'm
tone,
not
but
gonna-
you've
I'm
been
not gonna
pushing
sit
my
down.
buttons all day throughout this entire
Okay, you've been
trial, and
pushing
I
my
have
buttons
showed
too?
the utmost of respect
No,
for
you haven't.
and I don't
Absolutely
appreciate
not.
you impugning the integrity of this court.
If that's
I
what you want to
don't.
call it, that's fine, but it's not
Stop
accurate.
talking.
What you mean, stop talking?
I need to make a ruling. Okay,
Well,
I'm
let's-
purposely
let's
not
talk-
putting
let's
you in
talk
the
to-
other courtroom
Let's
right
talk to
now.
each other like adults then. Because I've never
please
told
kick
you
him
to
out.
stop talking.
I'm going to ask this question one more time, and if he doesn't answer it, I'll take it as a no. Do you want the opportunity to question Detective Casey regarding either his questioning or meeting up with your mom and your niece and nephew about possible testimony, or the search of your jail cell? Yes or no?
What was the problem with me asking the
All
question
right,
about
he's
the
not
jail
answering
cell?
my question. We'll move on.
I'm trying to understand. If I don't
we're gonna take a
understand,
break.
how do
We're
I
in
know?
recess, 15 minutes
How do
from
I
now.
know
Take
what
care,
I'm supposed to
everyone.
answer if I don't understand? And I don't agree to a stop.
Well, he doesn't agree to a stop line. And like I said again, that sounds like a personal problem. The fact you don't understand and that you don't know what's going on, that sucks for you, I guess. It's a personal problem though. Yeah, I think that's a well-deserved break. I'm gonna take a break as well, and then I'll come back and record the rest. It's starting to get more and more intense as the days are going on, so I definitely see what you all are saying. But man, I guess I'll go ahead and call this one here. If you enjoyed the video, please like, share, and subscribe. Hope you did something good for somebody today. Hope somebody did something good for you. And I will catch you guys in the next one. Peace.